appeal is dismissed, the bail bonds are cancelled. They should surrender by 23rd September.
For judgment item number 2, CRLA 525 of 2007.
The appeal is dismissed. Those who are on bail should surrender by 23rd. None appears dismissed and opposition.
Supplementary list, old matter item number 4.
Your item number 4, state is the appellant against the order of honorable single judge allowing
What's the delay, sir? There's a delay application.
Yes. My lord, there is a
Okay. Delay of 62 days is controlled.
Yes.
Yes.
the impugned order before the honorable single judge was allowing an application for mutation of the case line in favor of the writ petitioner. That was rejected by the Tahsildar, and the mutation case was rejected. Thereafter, he straight went to they filed the writ petition, and our only contention before the honorable single judge that this should be filed. He should be directed to file appeal against that, because mutation order can be challenged.
There's no stay of this order, sir. It's been in 9 years now. So,
but still, this
just
is
for
government
mutation,
land.
these are not matters which we should interfere. You say the only relief granted by the learned single judge of the High Court by the impugned order is a remission to the Tahsildar to consider the plea of the respondent for mutation of the land in their favor and pass an order afresh on their claims. Full stop. During the 9 years in which the present appeal has been pending, there's been no interim order. Full stop. The impugned order, therefore, should have already been given effect to. If not, it should be implemented within a period of 8 weeks from today. The appeal is disposed of. The court is not inclined to interfere with the impugned order. The appeal is accordingly disposed of.
Supplementary list item number 5.
Not pressed, my lord.
Not pressed, dismissed.
Item number 6.
6 minutes around 120 days delay.
All right, delays condoned. Yes, what's the matter about?
Here is a case. Petitioner challenges the impugned order under Annexure 1 Millard, while learned single judge rejected my application Millard's 36(2) of the Industrial Dispute Act. Millard's the management Millard's before the tribunal Millard's represent through the office consultant, one consultant Aaron Ratha Millard's, and he's looking after the case Millard's that that petition has been rejected under therefore thereafter I have filed a writ petition under and Lawrence rejected that on the ground that he is a lawyer, practicing lawyer, cannot be represented through to the management Millard's.
Correct. So what is wrong with that, sir?
The Lordship see Millard's my applications.
Where is the impugned order?
Impugned order Annexure 1.
Annexure 1 is only that.
Writ petitions.
It's like in.
Millard's impugned order is Millard's Annexure 2 series. T order is there. Millard's space 37. Annexure 2 series 34 Millard's, page 34.
Yes.
Is 3 orders Millard's. One order is Millard's work represented through the Millard's one dismissal employee Millard's. He is no more the employee in the association Millard's. He has represented to the workman. That has been also challenged. And another things Millard's 36(2).
These orders have not been stayed for over 9 years now.
No, Millard's now
what survives?
I have taken
worked itself out. This
Millard's, I have taken instruction. Matter is at the argument stage, and
no need
no
to
presiding officer is there. So that's
all right. You say due to long passage of time, and with there being no interim orders staying the impugned orders, the appeal has virtually been rendered infructuous, as pointed out by Mr. Monti, learned counsel for the appellant. The proceedings in the labor court are at an advanced stage. Consequently, the court is not inclined to interfere. The appeal is dismissed.
We are for the Union of India.
I am appearing for the respondent number 2, my lord.
All right.
Supplementary list item number 7.
7 is same marriage.
In view of the dismissal of 507, 508 is also dismissed.
Yes.
Supplementary item 8. Item number 8.
My lord, 100, more than 100 30 days, because the writ appeal has to file on.
All right. Delays condoned. What is the appeal about? Tell us.
My lord, in this case, what happened, the present appellant, due to the award of the Labour Court Sambalpur in ID case number 4 of 2005, directing to reinstate the opposite party number 2 workmen in service with 50% back wages, which has been challenged by the management for this, that is the writ petition 13580 of 2007, my lord. While adjudicating the matter, the statement of the management is that due to the financial stringency, they want to abolish that post, my lord. That is their case. And after perusing, after hearing, the Honorable Single Judge has directed at page 11 of the running page, in view of the above position of the law, since in the present case the petitioner society has already decided in its general to abolish the post in question, but Labour Court has not taken into consideration the said aspect for non-existence of the post due to the financial change of the society. Therefore, the award of the tribunal relating to reinstatement with 50% back wages is set aside, and this court direct the petitioner society to pay a lump sum compensation which is fixed at 60,000 in lieu of the reinstatement, my lord. My lord, what the management is playing, my lord, with a suppression, and thereafter, after immediate of this order, annexed to, I am sorry that I am not giving the version of that, my lord. In that case, on 37/2013, they want to fill up that assistant secretary post. Annexure 2 is says that, and therefore annexure 3 and annexure 4, that another person is appointed in the assistant secretary post, my lord. And in my case, I have also filed, they have filled up the secretary post. So the stand taken by due to the financial they want to abolish, that is not correct. So I am, in order to harass me, these systems are adopted by the secretary management, my lord.
All right. There's nothing in this. You say the challenge by the workmen in the present appeal is to an order dated 26th April 2013 passed by the learned single judge, disposing of writ petition civil 13580 of 2007, filed by the management, challenging an award dated 29th August 2007, passed by the presiding officer, Labour Court, Sambalpur, in ID case number 4 of 2005, by which the present appellant was the present respondent number 1 management was directed to state the appellant workman in service with 50% back wages. Paragraph. By the impugn order, the learned single judge has taken note of the fact that the post in question, that is the post of secretary,
Assistant secretary.
assistant secretary, had been decided to be abolished by the management at its general body meeting. And that since this fact had not been taken into consideration, the learned single judge considered it appropriate to direct that in lieu of reinstatement, the appellant should be paid a lump sum compensation of rupees 60,000. Paragraph. Consequently, the appellant seeks to point out that which is your miss case?
My lord, in this case, they have advertised for the post of the secretary. Therefore, I am filing that not to this. But
No,
they have appointed after 3 months.
States
That 3
that-
months, they have appointed assistant secretary. My lord.
The
That is my.
management has filled up the vacant post of assistant secretary after the judgment passed by the single judge, and an advertisement is issued for that purpose. Paragraph. However, in the present case, the petitioner has the appellant, sir.
May I pardon?
Who's it?
Sorry, my lord.
Ah,
My lord, Annex 2, 3, 4, which are showing that after 3 months of this, they have, by virtue of the resolution, they have engaged another person in the assistant secretary post.
right.
So the stand taken by them that due to financial transiency that they are not complying the order of the learned labor court, he is with a malafide intention. That is my humble submission. And till that I am not receiving any award amount.
Hat you can always move, sir. For recovering that 33C2 is there.
As per the order, 60,000 that has been directed by the
You file a review petition if you want on the basis of these annexures.
My lord.
Counsel for the appellant points out that even after the judgment of the learned single judge, a resolution was passed by the management appointing an assistant secretary, and therefore the ground that the said post had been abolished is factually incorrect. Paragraph, if that be so, it will be open to the appellant to approach the learned single judge for review of the impugned order, since this is a fact that is developed, that has come to notice after the judgment of the learned single judge, permitting the appellant to file the review petition along with the completion application for delay, explaining the delay on account of the pendency of the writ appeal. The appeal is disposed of. Yes.
Supplementary list item number 9.
My lord, in 9, yesterday your lordship has, in similar matter, your lordship disposed of on the ground of delay, my lord.
All right. In view of what is that number, sir? Anyway, the delay is extraordinary and unexplained. Accordingly, the delay is a condone application is
I will give in the
dismissed.
I will
appeal
give in
is
the course of
dismissed.
the day.
Same order in 10 notes.
Supplementary list item 11.
None appears dismissal of opposition.
Item number 12.
Item number 12 and 13, my lord. Here, senior counsel was engaged, my lord. My lord, because I suddenly got this, my lord, yesterday night, my lord, I could not, my lord.
Let us see
Take
what
up-
the matter is about, sir.
Matter is regarding, my lord, an order passed by the learned endowment commissioner directing the petitioner to be evicted from the case land, my lord, which he has purchased as back as in the year 1978, my lord. And by exercising powers under section 25 of the, my lord, Act, my lord. That order was challenged before the Honorable Judge, which has been dismissed, and thereafter this appeal is preferred, my lord. My lord,
Nothing in this, sir. Is absolutely.
my lord, what I pray, your lordship may call it 1 week, my
No,
lord.
no, no. We can
At
pass
least,
it over, sir.
at least next week, my lord,
No,
because
pass it over, sir. We'll pass it over. You get
pass it over, it is not possible to, my lord,
Can't be helped.
my
sir.
lord,
We can't keep adjourning matters like this. Sorry.
my
You can
lord,
pass it over, sir. You get ready with the matter. We'll pass it over. Sorry.
12 and
because the
13.
party has asked
Passed
me to say, my lord, in fact, a senior counsel has been engaged, my lord.
Whatever, sir. It's a
And
2013
he was
matter.
arguing the case at the stage of admission.
All right. Sir. We'll pass it over. You kindly address arguments. Yes.
Lord, after
Sub-
recess, then your lordship may take.
No, no. We can't tell you when. At the end of the vote, we called out the passing vote. Yeah.
Supplementary list item number 14.
May I please, your lordship?
Yes. Appeal, how many days?
Well, in this case, my lord, the transfer of land by a scheduled class person to non-scheduled class person, my lord, and the transaction is void, my lord. That is my, and my lord, I have also, there is also delay of 83 days, my lord. In
83
filing that,
days delay is condoned. 83 days, is it? 115 days, sir, not 83 days.
yes, my lord, 115.
All right. Delay of 115 days is condoned.
Now, so far as substitution.
Let's see. That can be allowed, sir. There's no problem. Tell us what is wrong with the impugned judgment of the single judge. That you tell us.
I'll file the consolidated appeal memo by tomorrow.
That's all right, sir. Tell us what is wrong with the impugned order of the single judge.
My lord,
Which page is the
I
impugned
have
judgment?
filed a petition under section 2 of OLR Odisha Land Reform Act, my lord, before the respondent number 2, that is Sub-Collector Principal Koranjia in the district of Mayurbhanj. And that case has been filed for restoration of the disputed property which is under the possession of the respondent number 5 on the strength of an registered sale deed executed on 1/5/1981 jointly by his father Sanatan Behera and uncle Mohan Behera, belong to scheduled caste community, my lord, in favor of the respondent number 5, who was a non-scheduled caste, valid permission from the competent authority under section 22 of the OLR Act, my lord. And thereafter, the Appellant preferred an appeal, and in the appeal, the appellant succeeded. Thereafter, filed the revision. In the revision, the appellant also succeeded. While thereafter, the respondent of 5 preferred writ petition before the Honorable Court.
Come to internal page 4 of the single judge's order.
Yes, my lord.
Hmm.
But the
Kindly read. sir.
yes, my lord.
Kindly read.
Thus, it is very clear that the court has no power to synonyms as equivalent to the caste specified in the order. In the case at hand, the cell deed in question was executed and registered on 1/5/1981. There is no dispute that the caste Keuto was included in the order. The schedule for the state of Odisha by Central Act number 61 of 2002, published in Gazette of India, exhibit number 73 dated 18/12/2002. Prior to that, Keuto caste was not in the schedule for the purpose of the constitution. The appellate and revisional authorities have accepted the petition's vendor as a member of a scheduled caste solely on the basis of circular number 17,659 STW dated 27/1981, which was issued on the basis of judgment by this court in OJC number 237 of 1978, in which it was held that Keuto and Koivarta, being synonymous to Dhibara, should be taken as included in the term Dhibara, which was then included in the schedule of the order. But that circular, so also the decision of this court, that Keuto and Koivarta should be declared to have been included in the schedule, has been rendered nugatory or inoperative consequent upon the law propounded by the Honorable Supreme Court in Nityananda Sharma's case, my lord. Well, the interpretation of the Honorable Appeals Court judgment, my lord, that has been misinterpreted, my lord, on certain grounds. Let it come tomorrow, my lord.
No, let's read it. No, we're not adjourning, sir. Sorry, we're not adjourning. What is this? You can't go on reading and suddenly ask for an adjournment. We're not adjourning, sir.
Well, I am not prepared fully, my lord.
No. We're not adjourning. Sorry.
Pass it over, my lord.
Pass over. All right.
Supplementary list item number 15.
15, may I please, Lordship. Dispute relates to the cost of the recovery of escape energy charges.
Sorry, sir.
Dispute relates to recovery of escape energy charges.
All right.
My lord, as per the after the verification meter, the team inspection team found that one phase is missing. Accordingly, directed to the divisional manager to take appropriate step for realization of 1/3 of energy cost, as the Y phase is missing since 2010. And thereafter, the divisional manager intimated to the consumer. Consumer, instead of complying the order, approached to the GRF. And GRF, your lordship, kindly come to the GRF order at page 31. GRF have passed the order for testing of the meter before the government laboratory, and simultaneously held that if it is found that Y phase is missing, then 1/3 of the amount has to recover as per the demand. Thereafter, party approached to ombudsman. And ombudsman, instead of directing to 1/3 of, he though confirmed the order of the GRFA, were directed to recover the amount only for 6 months, relying upon the clause 97 of the 2004 code. And against that, the divisional manager approached to the writ court. And the honorable single judge, without appreciating the fact that regarding the 1/3 cost, which has also been confirmed by the testing laboratory, your lordship kindly have a glance to the page 41, my appeal memorandum, annexure 11.
Yes.
The government testing laboratory has also reported there is a 2/3 of unit is consumed only, and 1/3 is left. And but the learned single judge, honorable single judge, has only, without considering the fact and circumstance, relied upon the decision of the ombudsman as per the regulation 97, related that has passed. That is the writ appeal challenging the present appeal, the order of the honorable single judge.
Right.
It is 1/3 consumption has to be recovered from the consumer.
The meter is fine, sir. The meter has been found to be all right.
My lord?
The meter has been found to be all right. So there is no question of extra 1/3 being paid. Unless the meter is defective, you can't say that you have to pay another 1/3 extra over and above the
It
actual
is not a
consumption.
question. Your lordship kind of glance to the annexure 11,
Yes.
page 41
Yes,
of my writ appeal.
yes,
It is tested by the laboratory.
correct.
So and so, your lordship kind of details energy meter, 3-page, 400, mechanical genius, and your lordship kind have to the next page, 3-page, point so and so. So, Y page, your lordship kind have towards the bottom, R page, Y page, B page. Y page is 0. Not recording. That is your grievance. STL government laboratory has also confirmed our inspection. STL Y page is not recording at all. So it has been passed the government laboratory electrical inspector. Your lordship kind of remarks. The voltage in Y page is not entering to the meter, and from the long duration testing, it is observed that meter is showing 2/3 consumption, that is 67% of the full consumption. Only 67% of the consumption unit you have charged, and rest of them have not been charged. That is your grievance. So the Supreme Court also in 1988 Supreme Court, page 71, has also escape energy can be realized from the party.
Yes.
Lordship kind of a glass to the 1980.
It's been gone once. For 9 years, point.
Your lordship kind of a glass of para 10
Yes.
of the judgment. In the instant case, it appears from the report of the assistant engineer of the state electricity board that one phase of the meter was not working at all. So no, there is undoubtedly a dispute as to whether the meter in question is correct one or faulty meter, and this dispute has to be decided by the electric inspector, whose decision will be final. That is the bone of contention in that case. And your lordship kindly have turned to page para 13 of that judgment. Para 13. We are, however, unable to accept this contrary view as it is obvious from the provisions of 26(6) of the said Act that dispute whether meter is correct or faulty would come under the said provisions and not dispute regarding the tampering the meter. In our view, the view taken about scope 26(6) of the decision cited above is correct. In the instant case, the dispute relates to whether meter is correct one or is faulty, not recording actual energy consumed in running the oil mill of the respondent. So this dispute squarely falls within the provision said Act, and as such, it has been rightly found by the High Court that the electric inspector who alone is empowered to decide the dispute. If the electric inspector comes to the finding that the meter is faulty and due to some defect it has not registered the actual consumption of electrical energy, then the inspector will estimate the amount of energy consumed and will fix the amount to be paid in respect of such energy consumed within a period not exceeding 6 months. So in total, the observation is the electric inspector who is competent to decide the dispute, and according to Annex 11, the electric inspector has come to the conclusion that only 67% is recording and rest percent is not recording. So it has to be recovered from the consumer. That is the crux of the matter. Neither the ombudsman nor the honorable single judge has held that it is defective so far as 1/3% is not recording. That has not to consider. And other hand, only 6 months. 6 months, it is not a case of a defect. It is a case of not recording one page. Meter consists of 3 page: R page, Y page, and a O page. So R page. So Y page is not recording at all.
Yes.
So that is the revenue which has to be collected from the consumer.
Yes. Lost concurrent findings are not good. They are purely factual, actually.
My concurrent findings so far as factual experience is it a question of law, and the GRF has passed the order in favor of the present petitioner by the ombudsman, relying on the wrong decision 97, which is not at all applicable.
Right.
And this decision has not been taken into care. And also, in the recent tax matter, Supreme Court has matter arising out of a consumer case has also said that escape energy has to be recovered from the party.
Yes.
You will also kindly take the view, kindly see the decision of present.
Yes.
This matter also arise out of escape energy.
All right.
You'll also, and arising out of order passed by National Consumer Forum. You'll also kindly, in lastly, in para 25, Lordship, para 25. In other words, the negligence of the part of the licensee which led to short billing in the first instance and rectification of the same after mistake is detected is not covered under section subsection 1 of section 56. Consequently, claims so made by the licensee after detection of their mistake may not fall within the mischief of nameless no sum due from any consumer under this section, appearing in subsection 2 of 26. Appearing 20 subsection 2. The matter can be examined from another angle as well. Section 1 of 56 as discussed above deals with the discussion of related supply if any person neglects to pay any charge of electricity. The question of neglect to pay would arise only after demand is raised by the licensee. If the demand is not raised, there is no occasion for consumer to neglect to pay any charge for the electricity. Subsection 2 of 56 has non-obstinate clause with respect to what is contained in any other law regarding the right to recover, including the right to disconnect. Therefore, if the license has not raised any bill, there can be no negligence on the part of the consumer to pay the bill, and consuming the period of limitation prescribed under Section 2 would not start running. So long as limitation has not started running, the bar for recovery and disconnect should not come into effect. Hence, the decision of Rahmatullah Khan and this will not apply. Therefore, we are of the view that National Commission was justified in rejecting the complaint, and we find no reason to interfere with the order of National Commission. According to the appeal, is dismissed. However, since the appellant has already paid 50% of the demand without pursuant to our interim order passed by this court on so and so, we give 8 weeks time to appellant to make payment of the belated of the rest of the amount. There shall be no order as to cost. So here is also question was escape energy and negligence before the consumer forum. So escape energy has to be recovered from the consumer. He has consumed and gainfully taken advantage of the energy cost.
All right. We'll reserve orders. Orders reserved.
Supplementary list item number 16.
Unappeased dismissal no prosecution.
Supplementary list item number 17.
As item 17, 18, and 19, well, it's the same order as item 9 because of delay, because I don't have the order. Item number 9.
So it's to be dismissed.
Yes.
All right. Both on ground of delays. 17, 18?
17, 18, and 19.
19. All right.
Supplementary list item 20.
20 minutes I am appearing for the opposite party.
All right. None appeals for the petitioner dismissed. No prosecution.
Okay.
Supplementary list item number 21.
Same order.
Supplementary list item 22.
21.
None appeals dismissal no prosecution.
Supplementary list item 23.
None appeals dismissal no prosecution.
I'm for the BDM.
All right.
I'm in PC Miller.
All right.
Supplementary list item number 24.
23, I am for the petitioner Miller.
Yes.
Sorry, 23.
23.
Miller. It's 23, I am for the petitioner Miller. There is a noting that the copy of the counter is not sought.
No, what's the matter about?
The matter is regarding the high-rise buildings in the Bhubaneswar and so also in the Cuttack Miller. The development authorities have filed a count with respective counters. So also the state of Odisha has filed their counter, my lord. So I pray the copy of the counter may kindly be supplied to me so that it can be adjudicated.
Tell us what the matter is about, sir.
The petitioner raises his great question that because of unregulated high-rise buildings. Am I audible?
Yes. Yes.
At this stage, I humbly pray that a copy of the counter may kindly supply.
You first tell us what the matter is about, sir.
It was admitted, my lord. So also the counter is filed because I am not.
Sir, if you're not interested in telling what the matter is about, we will read it ourselves. All right.
With respect, my lord, I am submitting that the dispute is concerning with regard to the action of the state authorities to control the high-rise buildings, my lords.
What does that mean, sir? What is controlling high-rise building means what?
But I humbly pray that a counter be supplied to me so that I can.
Sir, this is like a record which has got a scratch. You keep repeating the same thing again and again. You will not tell us what the case is about. You have your petition. Please open the petition, read the prayer, tell us what the matter is about, sir.
My associate is not with me, my lord. For that,
We'll pass it over. You better get your papers together. There's no way to read the High Court. Yes.
I pray for tomorrow.
Pass over. Sorry. Pass over.
Oblige, Lord.
So you show us the paperwork. You see, this petition was sent as a letter regarding non-implementation of earlier orders of the High Court for construction of speed breakers, oblique ramblers on the road near school areas concerning safety for children. Since this is too broad an area to be considered, it would be better if individual instances are brought to the notice of the court where specific directions can be issued for implementation. Consequently, the court permits the petitioner to file a more appropriate petition, giving full particulars. The petition is disposed of. He does. Am I just curious? Never sure. Petition was registered on the basis of a letter received way back in 2015 by persons apprehending demolition of their house. Consequent upon the acquisition of the land by the Mahanadi police. No interim orders have been passed till date. From the passage of time, there ought to have been other developments which have not been brought into court before the court. The amicus is also brought before the court. Developments as far as the land acquisition Act of 2013 is concerned. and the decision of the High Court of India and Indo Development Authority of Panohar. All of this would require a comprehensive petition to be filed. The court does not propose to entertain the present issue in the form of a letter petition, and it is disposed of as such.
Supplementary list item number
None appears dismissed in opposition.
supplementary list item 25.
Item 25, your lordship, became infectious. Your lordship.
Infractuous dismissed.
Supplementary item 26.
Item 26 on behalf of Archer, the counter copy has not been solved.
It's all right. What is the matter about, sir? Tell us what the case is about.
I don't have the brief, my lord. I couldn't
You
look
pass it over, sir. You can pass it over. You get the brief and argue it now. Pass over.
Item 27.
Flux of time, my lord, it has become in.
Constitutional petitioner states petition become infractuous. Disposed of as such.
Item 28.
Item 27 months, I'm for BDM management.
All right.
Item number 28.
None appears dismissed.
Item 28, my lord. This is a public interest litigation, my lord. As my allegation was, the so many people, the OP number 5, Didin Sarpanch, he had made illegal construction over government land, Gochar and forest land. Accordingly, government has filed counter, my lord. And they have admitted that there is enforcement cases initiated against the encroachers, my lord. And one more allegation I had made, that the rents which were collected by Didian collector, it was going to his pocket. But here, my lord, the government has in counter, have a glance at para 12. Para 11, my lord. They stated that the rents were collected 200 rupees from each person, and that was going to the government account. But that is wrong from their document. It is available to my lords at page counter affidavit at page, my lord, last annexure, my lord. That is not paging. B/1, last page, my lord.
Yes.
Your lordship, 3-4 lines, my lord. After local inquiry.
Yes.
After local inquiry, it was found that the last 4 persons, serial number so and so, village so and so, is paying money regularly on the panchayat office instead of revenue department. The panchayat office has encroached an area so and so. In so and so, this is for February. Regularly paying to panchayat, only 4 persons, not all. Accordingly, your lordship may dispose of.
All right. In view of the stand taken in the counter affidavit, that the encroachers, many of the encroachers have been evicted, and encroachment cases against the remaining will be taken to the logical end. No further directions are called for in that regard. We'll stop even as regards the allegation about payments being made. The counter affidavit explains in a tabular form the persons who have paying money regular to the panchayat office instead of the revenue department. Full stop. Clearly, therefore, some action has been taken even in that regard by the opposite party state. No further directions are called for. The petition is disposed of.
Supplementary list item 29.
Like public interest litigation. The senior citizen, also member of a freedom movement lordship, is before lordship. And lordship kindly stated come to annexure 1, a minor irrigation project which has been approved since 1992. In the name of elephant corridor, it is yet to be implemented. And there is, in fact, lordship, there is no appropriate decision either rejecting the proposal or, but in the name of elephant corridor, my lord, it is yet to be implemented.
It's not in the name of elephant corridors. There is a problem on the elephant corridors.
But lordship, I want to point out, because it's a policy decision, definitely government to take a decision. But you can just, I'm showing lordship 2 to 3 informatives, which can be reconsidered, only my humble submission before lordship. It can be reconsidered, lordship. Lordship state they come to page 90, lordship.
Yes.
Page 90, lordship, it is letter dated 27/9/2014, lordship.
Right.
Here, lordship, there is a letter to me regarding non-implementation of the project.
the rights, my lordship, first of all, forest clearance of involved forest land of 20.40 hectare is yet to be obtained. It is seen that this project is coming within the ICAT area of the Brutanga medium irrigation projects, as well within the elephant habitation. Lordship, third is that NPV of the involved forest, that is Lordship. Lordship stated, then come to page 92. Just 2 days after, my lordship, they gave me information. Lordship, kindly see. This lordship, just I'm reading only class 3 and 4 and 5. The proposed site is apart from elephant habitat is a part of elephant habitat. Executive Division Khurda has made an attempt to conduct Sabha through the BDC Nayagarh, but it has not been conducted. Overlapping of ICAT Sulia MIP with Brutang irrigation project will be ascertained after approval of the ICAT map of Brutang irrigation project. Executive Engineer MI Division Khurda has made regular attempts to obtain Sabha proceedings through the BDO Nayagarh, but has not been conducted so far. It is just contrary to the page 90, Lordship, the 27. Then Lordship kindly come to their counter, Lordship. Page 202, para 13.
Yes.
Here, they are replying that in reply to affirmations made in paragraph 13 of 227 of the writ petition is humbly submitted that alignment of Brutanga project has not yet been finalized, hence there is no overlapping of project. Well, on one hand, they are saying because of this reason they are not implementing the project, but here they are giving it is yet to be finalized, Lordship. Then we see another document, Lordship, I have annexed also at running phase. 287, Lordship. This is the report of the conservation Roman 10, Lordship. Whether forms part of national park, wild reserve, elephant corridor, etc. The reply is, Lordship, by the officer competent authority. No, not but sometimes a floating elephant seen in the locality. So it is yet to be declared elephant corridor. It is a large project, Lordship. It is a beneficiary. Lordship, effect to all the public.
Also, let them take. Let us not sit in judgment over whether they should have an irrigation project or not.
But only my humble submission, they are giving their report. It speaks with yet to be finalized. They yet to be declared this elephant corridor.
Yes.
So let them take a decision. Only my humble submission, Lordship. Because larger interest I am saying before Lordship, and a freedom fighter is before Lordship, and since 1992 he is fighting for this project, Lordship. At the fag end of his life, Lordship.
But if there's an elephant corridor, they can't have.
No, my lord, it can be avoided, Lordship. If they will,
we don't know. You give suggestions, then you make a fresh representation.
Lordship, that is my entire Lordship.
Mr. Dalai states that he'll withdraw the present petition with liberty to make a fresh representation to the government, giving suggestions as to how the irrigation project in question can be implemented, notwithstanding the existence of an elephant corridor. If such representation is made not later than 10th October 2022, should be considered on its merits and a decision thereon be conveyed to the petitioner within a period of 3 months thereafter. The court clarifies it has not expressed any view in the matter. The petition is disposed of.
Obliged.
We are for the OP number 1 and 2, my lord.
All right. All right.
Supplementary list item 30.
None appears to dismiss.
Supplementary list item 31.
Well, I am in BC.
Yes.
Well, the matter is infructuous.
All right. Infructuous.
Supplementary list item 32.
None appears to dismiss.
Supplementary item 33.
I plead your lords. As per counter, government has initiated, this is an enforcement case, government initiated lots of encroachment cases, my lord.
So, since the government has initiated encroachment cases, as I mentioned in the counter affidavit, those cases should be taken to their logical end, if not already done so. No further directions are called for, the petition is disposed of.
Supplementary list item 34.
My lord, I am applying for the illustrated reflectors, my lord.
Sorry?
My lord, in item 33,
All right. 34 is called out.
Item 34.
Lord, here is the case of the petitioner. He was removed from his office because of the misappropriation. The Lordship may kindly come to annexure.
Item 34.
34.
10724.
No. Sorry.
Construct excise office, the southern side of the national highway instead of northern side. So all this is not matter for PL.
No, he was mentioning some other item.
It's gone off winner.
34 non-appear.
None appears. This was not possible.
Item 35.
35 on behalf of Mr. Samal, my lord, kindly urgent for 2.
No, we're not adjourning.
He
Tell us what the matter is about.
He is seriously ill, my lord.
Let's see what the matter is about. You can go to the NGTs.
It is all
grievance in the present
DS.
petition is about illegal felling of trees over a jungle land. Full stop. It will be open to the petitioner to approach the NGT for such grievance. The petition is disposed of. Right.
Supplementary list item 36.
None appears. This was no prosecution.
Supplementary list item 37.
Item 37 and virtual mode, matter is infructuous.
Infructuous dismissed. Yes.
Item number 38.
My lord, this is regarding unauthorized occupation of a village pond, my lord. The natural source of water, my lord, for the
Go to the
community
NGT,
land.
sir.
But construction of the market complex over there.
All right.
The representation by to the collector, your lordship, under annexure 2 is still pending. There, my lord, the villagers have raised their grievance against the before the collector to look into the matter because it's a community pond, and there the entire source
Make a fresh representation because there's no proof of representation having been handed over.
they will file a fresh representation.
Counsel the petitioner seeks leave to withdraw the present petition, liberty to file a fresh representation to the authorities if any cause of action arises. And after following up on such a representation to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is grateful.
I am for option number 6.
Well, the proof is there at running page 19.
It's all
proof of that representation is at
right. That's only those cards.
That is those are all registered posts, my lord.
No.
Registered slips. Okay.
Item 39.
May I please, your lordships. The given case, my lord, the grievance is of the year 2011-12, wherein the Japanese encyclopedia, a particular disease cropped up, and so many children died because of that inadequate health measures. Therefore, my lord, and the petitioner has prayed for compensation, my lord. So, but at present, I think the present petition will not survive, my lord.
All right. In view of the subsequent developments, cause of action does not survive. The petition is disposed of. All right.
The appearance of opinion number 1 be recorded.
All right.
Item 40.
Item 40, my lord, kindly permitted to withdraw with liberty, my lord.
Counsel to the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation if any cause of action survives. This post is withdrawn with liberty is paid for.
Item 41.
41, my lord, infructuous.
Infructuous dismissed.
Item number 42.
None appears dismissed. No.
Supplementary item 43.
43, may please. Lordship, in this case, there's a noting that OP 7 has filed a counter. Because
all right. What's the matter about? Tell us.
But I have not received the copy, Lordship.
What is the matter about, sir?
The matter relates to the construction of barber shed near Narendra Pokhari, that is a holy place in Puri. And our allegation is that they are constructing it on the road.
What is this?
Construction of a barber shed.
Barber shed?
It is being constructed by Puri municipality, Lordship.
No, there's some Barika Chali means what?
Barika Chali. In Odia, we call it Barika Chali, Lordship.
I see.
Some sheds are being constructed for accommodating the barbers who will perform their duties during ceremonies
Lordship.
near the, that is a tradition that you
Lordship,
cannot-
but the plots on which they are constructing are roads. It has been recorded as roads. Plot number 128 is a road, and since it's a congested area, for that reason, we have, being the local inhabitants, have come up before this honorable court to.
No, it's only confined to one plot, sir. Plot 127.
Lordship, the OP7 has filed a counter because on the last occasion there was specific direction for, because there was apprehension that the PKDM might construct a wide road because of the Lordship. 5 years have elapsed, and Lordship is very well aware that the Mandira Parikrama Prakalpa has also taken place, and many and the roads are being widened. I only pray, Lordship, let them serve a copy of the counter. Lordship may take it up any day next week. I will just obtain instructions in that regard.
So this shed has existed for a very long time.
The shed is not there. As on date, there is no shed. Because
Then
of
why
the
are you
interim order.
worried?
Because of
There's
this
no shed,
interim
no
order.
worry then.
If there is no said, make him a
Counsel, the
he will
petitioner
make an
states that as of
interpretation.
date, to the best of his knowledge, the so-called barber shed is no longer there.
Yes.
That view of the matter, the cause of action does not survive. If any cause of action arises in future, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
Lordship, disposed of.
Yes.
Item 44.
Okay.
44, here the petitioner is a student mill challenging the notification under Annexure 2 for withdrawal of the earlier the examination pattern by the.
It's all infructuous. Counsel, the petitioner, the subject matter of the petition has been rendered infructuous to the passage of time. The petition is disposed of.
Item number 45.
The Lordship, Annexure 2 is pending before OP number 1, and that at page 17 there is proof attached, Your Lordship. The representations were sent to the Secretary, School and Mass Education. This is regarding malpractice in the board
Go
of
to the
secondary
local
education.
for the subject matter of the present petition be open to the petitioner to approach the local for appropriate remedies.
Item 40.
Yes.
Item 46.
46, my lord, both the cases are infructuous.
Infructuous dismissed.
Supplemental list, fresh admission, item 47. (47)
Admit fine, stay of recovery of fine will be pendency. The application is disposed of. You want to please say the LCR be requisitioned, the paperbooks be printed, prepared within 8 weeks and supplied to concerned parties. Thereafter, the appeal be included in the list of annullering matters. In the bail application, you say none appears dismissed on prosecution.
Your Lordship admitted.
Yes.
Supplemental list, item number 48.
48, may I please, Your Lordship?
Yes.
Lordship,
Admit, say stay of fine. How long have they been in, sir?
Lordship, the appellant, namely Vishwanath Baliyar Singh, his Lordship is in custody on dated 17/12/2012, and he is released on bail also on the same date, Your Lordship.
So basically, he's not in custody. Right now, is he in custody or not?
Yes, Your Lordship.
It's okay. So bail application is not pressed at this stage. Disposed of. All right.
Item 49.
Obliged.
Same admit stay of recovery of fine.
Obliged.
May pardon my books be prepared within 8 weeks. Thereafter, included in the list of annullering matters. You are appearing in this matter? Who's in criminal appeal? 644. Are you appearing in this?
No,
item
14. No, 14 that I am appearing that case.
How have they been in custody, sir?
So he's in custody. Mr. Panda is not in fact conducting the case. So there
No,
is a
you should know how long he's in custody.
Lordship, instruction, Lordship.
All right. The bail application is not pressed at this stage. Not.
So that may be liable for some time.
Yes.
Because there is a bereavement in his family. Today
It's all right, so you can file a fresh application.
Not with that liberty.
Yes.
Item 50.
May I please?
My lord, appellants has been convicted.
It's all right. Admit, you say the LCR election paper was prepared within 8 weeks thereafter. You say the appeal then be included in the list of final hearing matters. Stay of fine, that is disposed of. How long have they been in jail, sir?
My lord,
How long has he been in custody?
in this, during trial period, he was on bail. Now,
Then
since
bail is
the
not
date
pressed
of
at this
judgment, he
stage.
is in custody.
Yeah, not pressed at this stage.
Supplementary item 51.
May I please? Well, 51 and 52, my lord, are just sort of a common judgment, my lord.
All right. Admit, you just say LCRB requisition, the paper books be prepared. Stay of recovery of fine during the pendency of the appeal. The applications are disposed of.
In the second appeal, my lord, in the CRLA number, my lord, 659 of 2022, there is no allegation against the appellants, my lord.
How long have they been in, sir?
They were released on bail by this honorable court during trial. And now inside custody from the date of judgment.
Then they can wait. Sir. They're not pressed at this stage. All right. Disposed of.
Lordship?
Not pressed at this stage, sir. The bail application, let you file it after a while. Yes.
Supplementary stress admission item 53.
None appears.
Item 53, let's item 53. I pray, there is a development here. There is a school which is being constructed. These are the orders of your lordships. I pray that lordships may call it on Monday so that I can give my entire reply within that.
It has become infructuous because school has already been constructed.
No, school construction is commenced. It hasn't been completed. And your lordships, there was an interim order of your lordships.
What interim order?
Perhaps it was subject of the result of writ application.
What? For construction of school, how can we subject to result? No such interim order, sir. Sorry.
My lords may give me on the Monday, your lordships may call it for. I'll just give my paravise reply.
No, this is, which is your item petition number?
Well, this is 11081 of.
What's the prayer or something else?
Yes, because in the last noting, your lordships wanted me to.
Granting permission for permissive possession of the land for temporary relocation of slum dwellers.
Yes, my lords. Communal land, my lords.
What is the school and all? Where do you get the school?
No, we are going to locate the school on that floor.
I see.
They say that this should be allocated to slum dwellers.
No, that's a subject to result of the.
No.
I've been instructed.
Order dated 29th April 2021.
April 2021.
2021.
Any construction will be subject to the outcome.
Yes, please.
But the construction is complete now.
More or less, it is. He also knows.
No, but it's what I've been instructed. The construction is still, it hasn't been completed. That's what I've been instructed. Just incorporate the same into the reply melodies and your lordship may call it Monday.
Where is the reply?
Well, I have my reply at hand, but melodies today I've been instructed that the construction is on. So that is not incorporated in my. So I wanted to bring it on
is there a
record.
reply? One minute.
No, melodies, it's not there. It's not there.
Order of this honorable court, the matter was heard by the collector. Both the petitioner and others were properly heard, and order was passed by the collector. He has, I think that order has not been challenged. That is 10th March 2021. I was supposed to.
That was during the pendency of the application.
During
pendency of the application. During pendency of the application.
Correct. But by order of the court.
Already, yes, because the matter was already pending and shouldn't have been challenging that particular order.
My lord, one thing can be, I will serve the copy of the collector's order. He is having that. Let him file a challenging the collector's order.
Yeah. It will be open to the petitioner to challenge the order dated 10th March.
10th March 2021.
Of the collector Cuttack.
Passed
in
during
a
the pendency
substantive petition in accordance with law.
No, that is pendent during pendency of the case by order of the court.
During pendency of the case.
Right.
Yes.
The petition is disposed of at liberty as opposite. Yes.
This order was also communicated to his client.
So then subsequent to that, I had to file.
Yes.
Supplementary list item number 54. Item 54.
Item 54, Your Lordships. Your Lordship, the consolidated petition has been filed as per the order dated 19/4/2016, Your Lordship.
Yes.
In this case, Your Lordship, the petitioners are challenging the action of the Gram Panchayat to provide the ponds of the Gram Panchayat in improper manner, Your Lordship, which is in violation of the rules, Gram Panchayat rules, Your Lordship.
Who are the persons who have purchased the ponds?
They have been parties, Your Lordship, after the amendment of the petition, Your Lordship. OP number 9 to 18, Your Lordship.
Has notice gone?
No, Your Lordship. 9 to 18 notice has not been served, Your Lordship.
Then the 2015 matter, sir. What's the part?
The period of lease must have been expired in the
Yeah. Due to passage of time, the petition has been rendered infructuous, is disposed of as such. If any fresh cause of action survives, it will be open to the petitioners to seek appropriate remedies in accordance with law. Yes.
Supplementary list item 55.
Item 55 on behalf of Mr. Manas, Lordship. This is a PIL illegal encroachment and construction over government land by a sitting local MLA. He constructed a hotel over that land and using it for commercial purpose.
Is there a representation?
Lordship, may kindly see page 3, para 3. As he found that by encroaching upon the main roadside valuable land, which is also the river embankment, a hotel is operating on the entry point of Soroda. The petitioner made further inquiry of the matter and in the process have also obtained information from various sources and through RTIR and came to know that opposite party number 4, the MLA, who was a political man of
representation, bracket annexure 3, he examined by the collector Ganjab and after notice to the petitioner as well as opposite party number 4 and after giving them a hearing, a reasoned order shall be passed on or before 16th December 2022 and be communicated to the parties within a week thereafter. The court clarifies it has not expressed any view on merits. The petition is disposed of.
Supplementary list item 56.
Appears dismissal in opposition.
Item number 57.
In this PL, there is a representation, page 15, annexure 4 is there.
Item.
Though there is no endorsement, but we filed before the authority.
It's a problem, sir, unless you have a proof of permitting the petitioners to make a fresh representation to the authorities and after following up on such a representation to seek appropriate remedies in accordance with law. The petition is disposed of.
Supplementary list item 58.
My lord, I may be permitted to file my lord.
Yes.
Yes, my lord. My lord, this is the PIL filed by the petitioner. Is social activist, and my lord, the PIL regarding the challenging the advertisement by the opposite party number 2 for shifting the SBI branch to another place, my lord. Several representation and email were yes, my lord.
Bank being shifted to another place.
Yes, my lord.
So what is PIL to do with all this, sir?
My lord, several representations were given by the local persons that not to shift the branch, my lord.
What is there, sir? These are not matters of PIL, sir.
This matter
cannot bank branch should open at one place.
It's a policy decision, my lord.
Yes, yes.
New
Collector
stamp is
cannot
just
even
The
interfere with this.
is about shifting, having a branch of the State Bank of India not shifted from its present location at in Chaitanya Bazaar, is it?
Yes, my lord.
Chaitanya Bazaar area.
All right. These are matters of policy for the State Bank of India, and the court would not like to interfere in a PI. The petition is accordingly dismissed.
My lord, I have filed representation before the opposite party number 1 and later given to the opposite party number 2, my lord. That is the DGM of SBI. It may be considered, my lord.
No. We are not inclined. So if you want, you withdraw it. If you want, you withdraw the petition. All right. Okay.
Supplementary list item 59. Item number 59.
Nana, please.
50.
It's all private. It's a money claim dressed up as a writ petition. The praise in the present petition indicate that this is a money claim by the petitioner against private parties. So there is a certificate case number 9 of 2021 stated to be pending before the sub-collector Bhubaneswar. Full stop. Given the limited nature of the prayer for expedition, the one alternate prayer is for expeditious disposal of the said certificate case. Full stop. If the said case has not already been disposed of, it shall be disposed of within a period of 6 months in accordance with law by opposite party number 4. The petition is disposed of in the above terms.
Supplementary list item number 60.
My lord, in this case, my lord, there is defect, my lord. You are also allowed 2 time to remove the defect. And also, in meantime, I will appear in this case, my lord.
No. What is the matter about it? Let's see.
Matter, but I have no power. But in this case, I will appear in this case, my lord.
You are very kind, sir, but we want to know what the matter is about.
Matter about I have instructions to appear in this case, my lord.
No,
there
construction of Kudanagari.
Yes, he established
police outpost.
Yes, he established outpost from. I have earlier that is notification that to establish the outpost somewhere else in our locality, but the officials, government officials, try to establish other places. They have I also.
Did you give a representation?
Yes, I have also given a representation.
Which is at which page?
Which page? I have no file to appear in this case, man. That's why I am praying with you.
We'll see which page the representation is. No, you've not made any representations.
My lord,
You've not made any representation.
repent alert given to the DG police of Odisha, my lord, and also the.
Where is that? Copy of that is not there.
Your lordship, next week, your lordship, I will.
No, no.
I have no.
We can pass it over if you want to borrow.
I have no file here.
We'll give you the paper book. Give him the paper.
Your lordship I may be permitted to see the file because
Yeah,
copy has
pass
not
over.
been sought.
Both of you can see it.
Supplementary list item
61.
I may be permitted to withdraw.
Permitted to withdraw.
Union of India, my lord, number 1.
All right.
Supplementary list item 62.
May I please your lord? May I please your lordship? Lordship, the matter has been infructuous.
Infructuous is disposed of. Right.
Item number 63.
63 may I please? I mean virtual movement. The application for direction to opposite party regarding establishment of a police outpost, my lordship.
Everybody wants police outpost somewhere or the other. You have a representation.
My representation is my lordship. Annexure 1 is my lordship.
All right.
Before the
Petitioner's representation, Annexure 1 series be examined by the DG of Police.
My lordship.
Part number 2, and after giving the petitioners a hearing.
2 to 7
months shall be passed thereon not later than 12th December 2022 and be made available to the petitioner within a week thereafter. The court clarifies it is not expressed in the petition is disposed of.
Item number 64.
May I please, my lords? The defect shall be removed within 1 week, my lords.
What's the matter about, sir?
The matter relates to damaging the grazing ground of the village, measuring only 14 decimals, my lords, and without the knowledge of the collector, also the sub-collector and the tahsildar, and the village are subjected. But the Panchayat executive officer, without paying any heed to request of the villagers, is going to construct and damage the grazing ground.
Representation.
And a representation at Annexure 2 my lords, sir, running by 12 my lords.
But what is that showed has been delivered, sir?
My lords.
Acha, acknowledgement is there. All right. The petitioner's representation dated 30 June 2022 shall be examined by the collector Cuttack and after notice to the petitioners and opposite parties. 3 and 4. And hearing them, treason order shall be passed not later than 19th December and be communicated to the petitioners within a week, parties within a week thereafter. The court clarifies it is not expressed anywhere in that.
Supplementary list item 65.
May I please, your lord? Lords, may turn to page 61 in the input order. So,
yes.
May I drop my lord's notice page 61?
Yes.
This is the input.
Granting UGC scale of pay.
Yes, madam. UGC scale of pay to a teacher of
Sanskrit Institute, sir. Before going to the judgment, my lord, I'll draw my lord's notice to the UGC scale that the resolution issued by the state government is at page 15 annex. Let's me turn to page 15. That is the resolution.
1-5.
My lord. May I read, my lord? The question of revision of pay scale of college teachers on the basis of recommendation of Government of India was under consideration.
1 minute, sir.
Sorry.
You got it?
Resolution.
Page 1-5.
My lord.
Ah. 1989 resolution.
Sorry.
Ah.
That's clause 3 of that resolution. Clause 3. The question of revision of pay scale for college teachers on the basis of recommendation of Government of India was under consideration of government for some time past. After careful consideration, the statement have been pleased to decide to implement the scheme of revision of pay scale for college teachers with the following terms and conditions. That is my coverage. The revised scale of and other measures for improvement of standards of in higher education shall be applicable to all categories of full-time teachers working in all affiliated government colleges and aided non-government colleges either covered or eligible to be covered under direct payment scheme till 1st April 1989. That was the cut-off date. Then what? Let me see page 17. Why I am showing page 17. That is an explanation. All lecturers in the existing scale of rupees 700 to 1 and so on have completed age on the fact will be placed through a process of screening as indicated so on. So the scale is mentioned in respect of lecturers. Another notification was issued at page 21 because in that earlier notification the definition of college was not there. Page 21. Colleges under these instructions shall mean aided colleges which have been given government concurrence and university affiliation for opening +3 degree courses by 1st April 1989 and not thereafter. But the college in question, that was a Sanskrit college, till 31/1/1992, that was not a +3 college. Let's see page 27, annex 3.
What is the position? Have you implemented the implement order or not?
Let's stayed.
It's already been stayed.
Let's granted. My lord's order. Let's see 20th September 2021.
20th September.
My lord. And Mr. Kabbi Satpathy was appearing for opposite party. Not appearing.
Been served.
He was appearing.
B.K. Satpathy.
Kabbi Satpathy.
One Mr. B.K. Satpathy, advocate, was earlier appearing for the respondent. Today none appears. Interim order to continue in the interest of justice. 14 December.
Supplementary list item 66.
My lord, pass over item 60. 60. I have verified the record. There is actually no representation.
You make a fresh representation. Item 60
Yes,
is permitting the petitioners to make a representation to the authorities.
Yeah, sir.
And following up in such, and after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of. Yes.
Item 66.
There is no delay.
The appeal is disposed of. Since it is stated there is no delay. 188 to 22. And 187, dispensing with certified copy of subpoena.
Let's turn to page 15, annexure 1. This is the input order. The direction was to give promotion during pendency of the criminal case. In similar cases, your lordship has fixed it to 28th October.
Same order. Notice 28th October till the next date of hearing. There shall be a stay of impugned order. Right.
Supplementary list item 67.
My please. My lordship, there appears to be some defect in the noting. 1 week time may be allowed to remove that.
All right. Defects be removed within a week list thereafter.
Item 68.
68, my lord.
All right.
Supplementary list item 69.
My lordship, in item 69, I'm praying for 2 weeks time to remove the defects, your lordship.
It's a fresh appeal?
Yes, your lordship.
All right. To admit LCRB requisition. There should be a stay of file. That is IA number 1243. That's allowed. 1244 not pressed at this stage. To be included in the list of final hearing matters after consideration of paper books.
Grateful, your lordship.
Supplementary list for admission item 70.
As item 70, I'm seeking a passover on behalf of Mr. Katkia.
My lord, I pray, my lord. I pray, my lord, in that case, which is a matter which was referred to the division bench, whether magistrate can take cognizance in a sessions tribunal offense.
So there is one clarification I wanted. Let us go petition by petition, sir. Because after the decision in Dharampal, the earlier decision has been overruled. The Constitution bench in Dharampal.
No. All other earlier decisions have been overruled.
Overruled.
And Dharampal has been taken note of in 2022 Supreme Court.
And SWIL has been affirmed. SWIL has been affirmed. So the position therefore will be in these cases, the impugned orders will have to be sustained. Because here cognizance has been taken by the magistrate.
Cannot take. In that case, my lordship, I pray only last time Mr. Katkia has referred some decisions and he has...
No. That is already, it's a Constitution bench judgment, sir. We can't adjourn it again and again. You please look at the Constitution bench judgment in Dharampal.
My lord, before going to the case, let me see the reference. All the reference.
That reference, now this Dharampal answers the reference completely.
What I want to say, my lord.
Yes.
Is 4 of the reference.
Yes. This is in the
apex court in the case of Raskishore Prasad.
Correct.
Ranjit Singh.
Correct.
And Kishori Singh.
Correct.
Reported in so and so. When an offence exclusively triable by Court of Sessions is alleged to have been committed and the matter is investigated, magistrate has to go by the persons named in the charge sheet and not to add or subtract the list, having no jurisdiction in that respect.
All these three decisions
all the decisions have been taken note of and overruled.
Overruled. That's what. So this order, therefore, is the answer.
And so it has been answered.
Correct.
And that too, that has also been taken note of in 2022, volume 86, OCR Supreme Court 474 by Honorable Justice Binit Saran and Aniruddha Bose. Nahar Singh versus State of UP. Nahar Singh versus State of UP. This Dharampal Constitution bench has been taken note of.
Correct.
Last time, Mr. Katkia has given some decisions, my lord, and
Nahar Singh. I have noted that.
He has also mentioned.
They have Supreme Court has approved my lord Kishan Singh's case.
Yes.
93 volume 6 OCR.
Correct. So all these orders taking cognizance have to be upheld. The challenge has to go.
No, man. Your lordship may kindly see that Dharampal case, my lord. Again, once again, I will place my lord. Para 24, my lord.
Yes.
Para 24, my lord. In our view, the magistrate has a role to play.
Yes.
Taking the case to the Court of Sessions upon taking cognizance on the police report submitted before him under section 173, subsection CRPC. In the event the magistrate disagrees with the police report, he has 2 choices. He may act on the basis of a protest petitions that may be filed, or he may, while disagreeing with the police report, issue process and summons to the accused. Thereafter, if on being satisfied that a case has been made out to proceed against the persons named in column 2. The report proceed to try the said persons.
Correct.
If this is important, or if he was satisfied that a case had been made out which was triable by Court of Sessions, he may commit the case to the Court of Sessions.
Correct. He will commit it. Correct.
So we have challenged the order of cognizance, my lord. He cannot take cognizance.
No, he can take cognizance and commit it.
No, my lord. Cognizance cannot take.
Yes.
No, my lord.
So very clearly this says that.
No, my lord.
Yes.
Answer is at page 34.
Absolutely.
Your lordship may kindly see.
Answer is at page 34.
Yes. In fact, all the earlier cases been overruled, specifically overruled.
Answer is at paragraph 34.
Yes.
Your lordship may
The
kindly
view
see.
expressed in Kisum Singh's case, in our view, is more acceptable.
Correct. In fact, he can take cognizance of the offence in respect of persons in column 2, and then he will commit it to the Sessions Court for trial.
Sessions Court is only entitled, my lord, not the magistrate.
No. That view has gone now, sir. That view has gone. That was the older view. It has been overruled specifically in Dharampal. Dharampal specifically overrules it.
No, your lordship. Then your lordship may kindly call it next week, my lord.
No. We're not adjourning it again. We wanted to make this absolutely clear to all of you. That's why we listed it today.
Mr. Debasis Ponda, my lord, who is absent, he has also.
No, sir.
His associate is probably present, my lord. But he has gone outside, my lord. He has also requested me for one adjournment so that
No, one thing we'll do, we'll just reserve orders. If you want to file a note, you file a note. Because the position is absolutely clear, sir. The position in Constitution bench is absolutely clear. We won't adjourn it. We'll reserve orders. You file a note.
Your lordship only may give one chance only.
No, that's all over, sir. That's all over. You say orders reserved. Any of the parties who wishes to file a note of argument should do it within 3 days. Right. Yes.
Supplementary list item 71.
May please your lordships. Lords, this is a public interest litigation which was initiated on the basis of a petition filed by somebody, and this honorable court on 19th December 2013 had observed like this. Peruse the contents of the petition regime.
So the court amendment rules. So just read a 6 July order.
Yes, brothers. The 6 July order, brothers, I do not have.
What is this, sir?
I have got the order sheet copy. I do not have.
Sorry, 6 July. That was the last order we had passed.
Yes, brothers. I have given the copies of these documents which I had filed to the other side, brothers.
No, that you have. You have to file a response. The state's response. What happened? The compilation is given by Mr. Das.
Can I, before they say, can I say 2-3 things?
No, let them. They had to file it, sir.
Yes, my suggestion is, like road and airways, this ferryghat, the waterways is used by many people. For them, there is no provision of any insurance.
No, that is what the order is, sir. That 6 July.
I'm sorry. I'm sorry, Miller. Extremely sorry. Extremely sorry.
You have to file an affidavit. What happened?
Yes, giving some.
You see, no affidavit has yet been filed in terms of by the state in terms of the order dated 6 July 2022. Mr. Ishwar Mahantiri seeks a last opportunity to do so within 8 weeks. An advance copy thereof will be served on Mr. Das, the learned senior advocate and amicus curiae.
Obliged.
List on 5th December.
Supplementary list item 72.
Please, your lordship. This is a PIL seeking direction from the Honorable Court for upgradation of a upper primary school to high school. In the last occasion, your lordship has specifically directed to take instruction whether the government land is available in that village for development of that school. In the special counter affidavit, they have filed that in premises government land is insufficient. As such, your lordship directed to take instruction whether the government land is available in that village or not. It is available, sufficiently available, and it can be developed.
Your lordship can have a glance to order dated 21st of June.
And also thereafter, the Tahsildar furnished a report to the Lordship. I have a glance that report.
No, this is 12286.
Yes, ma'am. 12286/15.
There's something about the bridge being constructed. What is that?
No, that bridge has not been constructed. That admittedly they have admitted that 37% of the bridge has been completed. For last 5 years, that is not been completed. They have to give the work to some other contractor. That is the admission of the opposite party.
Government is not in a position, sir. Have you seen the 21st June?
Yes.
For that, your lordship.
You had to take instructions, sir.
Yes.
They have told the court that they're not in a position to upgrade the school, since sufficient land is not available.
Land is not available within that premises, but in the village, sufficient land is available.
No, you were to take instruction. You took adjournment last time to seek
Last time, my lord, I have applied for some copies, but I have not been provided with. That's why I am submitting with
what certificate copies of what?
About the land from the Tahsil, because I cannot just land documents. I cannot provide the availability of the land, government land.
No. So what?
So I will file affidavit after 3 days, so that I will get it. I will file an affidavit. That I can do.
Mr. Rao,
government land is available sufficiently. They are not denying that. Government land is available, but not within the premises is not sufficient. But government land is available in the village, in the revenue village.
That's not what they said, sir. Last time they said they are not in a position to upgrade the school beyond 8th class, and sufficient land as per the prescribed norms for such upgradation is not available.
In the premises.
Sir, how can it be that once some few classes will be here and some other classes of that school will be somewhere else? How can it be?
Because of the natural barrier, the Rescula River is there. Your lordship typically taken cognizance of that because of the natural barrier. Students are not able to reach to the school because of the flood and very big.
1 minute, both of you talk. I can't hear.
Because there is a very big river, and in the rainy season specifically, students are facing hardship to cross the river, and there is every danger to cross the river also. So your lordship directed that if it can be upgraded, the government should take cognizance of it. And in the premises itself, the sufficient land is not sufficient. That is their specific averment. In the premises, school premises, they are not available. But in the village, government land is available. That instruction I have got.
You have to file an affidavit. Mr. Raut maintains that in the village in question, land is available.
Yes, ma'am.
And states that he will file an affidavit giving the details at least 1 week prior to the next date with advance copy to counsel for the state, the counsel for the SNME department to enable him to obtain instructions. 7th December.
Supplementary list item 73.
As item 73, as per the last order, we are supposed to file an affidavit. That affidavit has been filed, and the inquiry report has been annexed. My lords, I'm giving copies of the affidavit because it was filed yesterday. My lords, this is with regard to my lords drinking water issue in this particular area in Jagat Singhpur. My lords may see para 3 of my affidavit. In the said village, during inquiry, it was found that there are 8 number of running tube wells. Besides, 5 tube wells have been periphery habitation of the said village to meet the day-to-day drinking water requirement. Therefore, the allegation that the people of the said locality depend only on 4 tube wells are not correct, milords. Because, and milords, with regard to drinking water availability, there is a piped water project which has been completed, and so drinking water, my lords, has been made available to the villagers. And the annexure A at page 3, my lords, that is the inquiry report. In the last line, my lords, we have said, keeping in view of the above fact, because there have been tube wells as well as these piped water that is being supplied. There is no water scarcity in village Brahma.
an affidavit, counter affidavit dated 6 September 2020 has been filed by the Assistant Executive Engineer, Rural Water Supply and Sanitation Subdivision, Paradip, stating inter alia that in village Bharmarkola, coming under the Portanai Panchayat, there are 8 running tube wells, 5 of which, apart from 5 tube wells in the periphery habitation, to meet the day-to-day drinking water requirements. Further state that drinking water facilities has been provided to different villages, including the village in question, that is Bharmarkola, through rural piped water system. That way, no further directions are called for.
Supplementary list item 74.
Pardon, in item 70. In item 70, I had filed a short note earlier.
Yeah. So only if you need to file any further note, you need to.
Item 74.
That may I please, Lordship? That if your Lordship would look at the earlier orders, his submission was advanced by the other side, the municipal corporation, that a SLP is perpetually filed before the Honorable Apex Court against my Lord's judgment. That is, my Lord, Kalyani maternity, if your Lordship remembers.
Correct.
That is with regard to the imposition of the holding tax besides the property tax.
Correct.
So by virtue of the transitional provision of 694 of the Corporation Act, that tax collection is set. Whatever was being paid under the old Municipal Act, that would be deemed to be the tax under the new Act until they resort to the specific procedure for imposition of the tax, which they have admittedly not done so far. So the SLP is allegedly pending in Supreme Court.
Because as far as third sub-item is concerned, that is related to holding tax.
Both the issues are interlinked. If
some defect that could not be converted to SLP, I pray some more time may be granted. In the meantime, it will be taken up, my lords.
My lord,
as far as third item is concerned.
Item 1 and sub-item 2, my lord, they are concerning the user. And that is segregated by my lord by an earlier order. The writ application presented by my friend is old 3.
On 10th March, my lords.
Yes, ma'am. Yes,
but
ma'am.
still it is coming, my lords, along with the on 10th March, my lord had segregated the third item.
Item 1 and 2.
Let your Lordship may kindly peruse
that
the
is
order.
A single bench assignment, my lords. That is. They are also enjoying the interim order also.
No, it's covered by a division bench judgment.
No.
My lords,
that is
Kalyani maternity is a division bench judgment of my Lord Chief Justice sitting with Honorable Justice. So that has this.
Sub-item 3, my lord. Sub-item 3.
No, 3 or 2, they are interlinked. Lord, your Lordship may kindly look at the order.
No, not at all. Sub-item 1 and sub-item 2 exclusively for user fee. And that is been segregated by my lord last order in the month of March.
Let your Lordship may just
10th March.
Lordship may kindly peruse the order dated 16/3/2017 in WPC number 11885 of 2016. Just a minute. That's the order which was passed in the presence of my learned friend Mr. Mahapatra. My Lord, 16th March 2017 by my Lord then Chief Justice Saran and Dr. Justice Sarangi. My Lord, Sri Manas Mahapatra and Senior Counsel along with Sri S. Patnaik put in appearance on behalf of the contesting opposite party number 2 means my Lord the corporation. He prays for and is granted 10 days time to file counter affidavit. The petitioner shall have a week thereafter to file rejoinders. Considering the facts and circumstances of the case and keeping in view that the petitioner is already paying holding tax under section 131 of the Orissa Municipal Act 1950, read with section 694 of the Orissa Municipal Corporation Act 2003, it is directed that till the next date of so and so. This is the order. Why this? Mr. Mahapatra, please allow me. We can submit that at a time. Your Lordship may kindly peruse section 131 of the Municipal Act, the old Municipal Act. that includes all those taxes, the tax, Latin tax, water tax, lighting tax, drainage tax, everything, my lord. They have been, of course, segregated under the new Act, Orissa Municipal Corporation Act. My lord, that is, my lord, is a issue because they are interlinked now. If they are collecting the user fee, so far the Latin tax, drainage tax, everything is concerned under the old act, until and unless, my lord, they resort to the mechanism contemplated under the new act, my lord, this levy is not permissible. That is why, my lord, on the last occasion, if your lordship put, my lord, the order dated, one second, my lord, order dated 21/12/2021. Your lordship may kindly peruse. Your lordship's order. Mr. Mahapatra, learned senior advocate, my lord, 21/12/2021.
Yes.
Mr. Mahapatra, learned senior advocate appearing for the BMC, insists that the concept of a user fee is different from that of a holding tax, and therefore this petition may be segregated from the rest of the batch. Mr. Acharya so and so. However, joins issue and maintains that this issue is incidental to the issue of holding tax because, my lord, 131 covers those taxes which they are collecting, my lord, combinedly. So therefore, unless this issue of property tax vis-a-vis holding tax is decided as per by the Honorable Apex Court, my lord, this issue cannot be decided separately. That is why while admitting the petition in the presence of the Municipal Council, the court has said so. So let them, if they want to, my lord, that it should be hard now. I have no issue. Let the petition be allowed. So therefore, they may join, go to Supreme Court against that. But they submitted that the issue is pending before the Supreme Court. At least there are 3-4 orders, my lord. So lordship put, submission was made on behalf of the corporation. Lordship may kindly see order dated 21.
Mr. Mahapatra, let it come after the Supreme Court decision.
That's correct.
May I submit, my lord?
Yes.
Kind glance to the cause title of this writ application.
Right.
Application challenging Bhubaneswar Municipal Corporation user charges regulation 2000.
Correct.
So therefore, my lord, regulation 2015 came in pursuance to a JNRU scheme introduced by the Government of India and 74th Amendment of the Constitution. Therefore, my lord, in pursuance to that, Government of Orissa accepted by Gazette notification to implement such scheme. Just kind of glance to page 52-58 of my counter, this federation case. There it says the Government of India introduced that because of the Swachh Bharat scheme, a scheme was introduced called Mission Urban Ministry to pay these ULB charges. That's my kind glance to page 53, kind of a glance. This is a new introduction of law by the Government of India by scheme and law. And therefore, that which was accepted by the state government in 2012 Gazette notification. It has got nothing to do with the holding tax. It is an user charge to be paid by the hotels, hospitals, and house owners. Those are providing, the corporation is providing express service to these agencies. Therefore, this additional needs to be burdened by. So that is not relatable to holding tax. And my lord, by law also, please kind of a glance to section 193. The user's charge is a separate provision. Holding tax is a separate provision, 192 and 193. That is what has been introduced. 192 concerns to holding tax, power of levy of taxes. 193 is a power to levy user charges. These are two separate under the law also. So now that cannot be clubbed together. 192 permits the corporation to charge taxes, levy, and property. So far, the 193 concern, my lord, it is a separate provision under the law, power to levy user charges, and which has been implemented by government notification in 2012 in pursuance to the Government of India's guideline. And that is being challenged here. So that cannot be a combined prayer that the holding tax and user charges is similar. That's my submission.
Yes, Mr. Acharya. This is only for de-tagging the matters.
Yes,
he wants these to be separately heard.
Sir, what I respectfully submit that the issue admittedly with regard to the power of the municipality to impose levy this tax under the new act is an issue. 131 so far the old act is concerned. whatever taxes have been, made provision have been made under the new act, they are already covered under 131, which the corporation is admittedly collecting. That is inclusive of this 193 tax. It is not, separate. So the question is whether they would levy the tax under the new act following the mechanism provided under it, or they would continue to collect the tax levied under the old act, which is saved under 694 of the new act, section 694 of the new act. That's the limited issue. The issue so far the 694 interpretation is concerned and levy and collection of tax is concerned, that has already been answered by my lord in Kalyani maternity case. So the corporation advances a submission that they have gone to Supreme Court and matter is still pending. At least there are 3 orders. Both the matters were heard together. Now I do not know what is their intention. They want to take it to a single bench. And my lord have already delivered a judgment. I don't think that why this bench is not compatible to them. So
no, Mr. Acharya.
That's not the issue.
No, Mr. Acharya, it will only mean this. Mr. Acharya, it will only mean this. If, according to you, the division bench order covers UC as well, then the single judge will follow that.
No, that's true, Millard, but from the beginning, I do not know why this attempt is being made. It's not fair, Millard. That is what my submission is. Lawyers should not make this, that the issue should not be had by. If self-same issue has already been decided by
Mr. Acharya, let us be clear on one thing. The judgment we delivered by us was on holding fee.
Holding, yes.
It was not on user charges.
No, Millard, that is property tax. Millard, that is the confusion which they want to create. So it Millard requires a full dressed hearing. It can
not like this.
I make a
my learned friend is submitting something
any
wrong.
date may be fixed, Millard, for hearing. I will Millard advance my submission. This is not, Millard, they want to segregate, but my humble submission is that if your lordship, they say it's a PIL matter.
Under the old law, my lord. Under the old law,
Mahapatra, please allow, at least we should know we should not
confusing.
Bad confusing
the whole issue. We are confusing the whole issue.
Say argument
you cannot mix up two laws. You cannot mix up 2 laws together. That law was, my lord, his case is under the old law, there was holding tax. By new law, the property tax has come. I don't dispute.
No, nobody says no.
But the concern, there is no user tax. There is no user tax in the old law. We only to after 2003 Act.
All right, whether it is the old law or new law, let a date.
There is no law at all.
We will address one by one. But this argument, one by one is not proper.
It cannot be. Please have a kind glance to 193 section. Lordship would be very clear.
Taxes system.
131, your lordship may kindly see. 131 of the Odisha municipal. This is not fair. We can't, when I am submitting, you will also make submission.
You are confusing the whole issue.
Yes. So section 192, Mr. Acharya.
Mr. Mahapatra, I know is very anxious because pressure may be very heavy on.
No, 1 minute. Section 192, Mr. Acharya. Mr. Acharya, section 192 talks of power to levy taxes.
Nobody says no. But the
and 193 is a separate provision which says power to levy user charges.
No, Millard, your lordship may kindly look at 131, Millard. User, Millard, the tax, particular tax which what they want to collect, 131 of the old act. They are already paying that.
Now they have separated it out.
No, maybe, Millard, but property and, Millard, your lordship may kindly look at 131, that would be clear. Power to impose taxes.
Correct.
The municipality may from time to time at a meeting convened expressly for the purpose of which due notice shall have been given, subject to the provisions of this act, impose within the limits of the municipal area the following taxes and fees or any of them. These are A2, I am reading one by one.
You don't read everything, sir. Don't read everything.
Everything it covers. One night. So therefore, the limited question before my lord is, it covers the entire tax. User fee, property tax, holding tax, everything, whatever they want to. We don't have any objection to the payment of tax. Municipality gives the curiosity of the municipality shown in the courtroom should be reflected in their executive action. They should come out with the mechanism provided under the Act for collection of the tax if they are so keen.
Did not advise the municipal corporation.
Just a minute, Mr. Mahapatra. This is not doing. Yes, 131 covers everything. That is why, while admitting the writ petition, My Lord Chief Justice Saran and Dr. Sarangi, it's a very discussed, though it's an interim order, my Lord, that answers. So let
by the time there is no counter. By the time there is no counter, it is the only stage of admission.
The answers. Lord, very this, not the me. Lord, let a date be fixed. I don't have any, Lord, your Lordship may take up for hearing. Let Mr. Mahapatra come, we can argue together, your Lordship would decide.
Ready, but let it be only for this user charges.
Lord, 16, 6
don't
years.
Mix up these two. Don't mix up these two.
I have no intention to mix up. Your Lordship may kindly, therefore, whether this 694 transitional provision.
Because there is a order of my Lord in that holding tax part, he wants to mix up.
will not show that he has a weak case.
Oh, okay, Mr. Acharya, let's be clear. Mr. Acharya, let us be one minute. Mr. Acharya, you're in 7090 of 2016.
Millet?
No.
Are
you in 70 first matter, the first sub-item?
First matter, I'm not there.
So who's appearing in this first sub-item?
Yes.
There's the connected matter in 11.
You're there.
Yes.
So here the challenge is to the user charge.
Yes.
So my Lord may take it up next week so that.
This confederation will have similar issue. In number 2, sub-item 2 is the similar issue.
User charge.
So therefore, I think this the number 1 petition, 7.1 item issue, he might have submitted that, let it be connected with that. I don't know how it has come with this. But this 11,185 of 2016 and the subsequent matter, 9929, filed by the Confederation of Citizens Association of Bhubaneswar, they are interlinked. So therefore, my Lord, what I humbly pray, let your Lordship fix any date, Lord, any date, whether they want to argue independent of your Lordship's judgment, so far the challenge before the Honorable Apex Court is concerned on this matter, Lord, I am prepared to argue. Let your Lordship fix a date.
From the beginning, my Lord,
Mahapatra, let us come to the cohort, let us have a physical hearing. I think because this is
my Lord, then 11,185 were coming together always. It is only Mr. Acharya club, the third item, to our item. That's the problem.
Mr. Acharya, the third item has to do with holding tax.
Yes.
Whereas the first 2 items are to do with user charges.
No, Milord, your Lordship, no, that is not the case, Milord. It requires
No, 9929. No, let's try and understand. 9929.
May be different.
No, 9929 of 2020. That is the third sub-item.
Corporation Act.
That questions the rejection of your representation against the revision of holding tax.
Your Lordship is correct. I am not disputing that, Milord. But the question is,
whereas the other 2 petitions are to do with user charges.
Milord, your Lordship is correct. I am not on that. Your Lordship may kindly turn to 694 of the Corporation Act. Milord, Article 265 they can circumvent and say that we will impose tax without authority of law. That is the Milord, your Lordship may kindly turn to Orissa Municipal Corporation Act 694. Milord, what I propose, why, Milord, I am prepared to argue this matter. But your Lordship may fix a date, any day, Milord, any day, in the week commencing from 19th. I will come and argue. Mr. Mahapatra should also feel happy that let us come to the court.
And happy or unhappy. The question is, you are mixing 2 laws to have one argument.
I
mix up together for one argument, which is already settled by my Lord's already judgment is there.
Certainly, Mr. Mahapatra, you are senior to me in age and you have a better understanding and better interpretation.
No.
But I am not. Please come, let us argue on the case. I respect your knowledge and wisdom.
No.
So I always confuse, you always try to clarify. I respect your wisdom. Thank you.
You are only taking advantage of that interim order.
The holding tax, I think we have to await the decision of the Supreme Court since the judgment is in challenge.
That's correct. That is all fairness, Milord. 10 years they have been waiting. I don't know why they are waiting also, Milord.
No.
Prevents the municipality to, Milord, come out with this mechanism to collect tax. I don't know.
No, Mr. Mahapatra, there's only one. Mr. Mahapatra, there's one commonality in the first 2 sub-items.
Yes.
They are challenging the validity of that clause 6.2 of the Bhubaneswar Municipal Corporation user charges regulations in both petitions. The challenge to validity of regulation has to still go before the DB or it has to go before the single judge?
That is to.
It is a division bench matter.
Any division bench, I have no objection.
So in which case it has to be anyway in the division bench only.
Both the matters, there is a challenge.
Anyway, are these PILs? They are not PILs.
First, these are both are PIL. Both are PIL.
Milord, virus, Milord, any
Item
PIL,
1,
there is
from item
nothing
1,
called
from item 2 are PIL. And
Okay.
they are
PIL is also a writ
the
petition.
user service.
In which case it has to be here anyway, Mr. Mahapatra.
My lord. By my lord. By my lord. That's it.
Then we'll only show it as two separate item numbers.
Only.
Otherwise, it will be before the same bench.
Yes.
So the same bench, and my lord, the whole issue would be, my issue is that user charges are the separate law.
While hearing the matter, we'll deal with it separately. It doesn't matter whether they're two separate item numbers or one item number with sub-items. The effect is the same.
Milord, the single judge, then writ appeal, then Supreme Court, Mr. Mahapatra.
They are challenged. They are challenging.
Put all three matters. It is clarified that while writ petition civil 7090 of 2016 and 11885 of 2016 question the levy of user charges in terms of section 193 of the
193.
Orissa Municipal Corporation Act
Orissa
2003,
Corporation Act.
read with clause 6 bracket 2 of the BMC user charges regulations 2015, writ petition civil 9929 of 2020 questions the levy of holding tax.
Levied on.
Right.
Levied under the old law.
Levied under the Orissa Municipal
Municipal Act.
No, Milord, Milord, may I clarify for a 1 second? Milord, under the new act, those taxes have been segregated.
Correct.
But under the old act, it was
Correct.
a composite tax.
Correct.
Comprising of this property, user fee, everything.
That's right. That's right.
That is why, Milord, both the matters I submit that they are
As far as the latter issue is concerned, since the judgment of this court in Kalyani, what is that full said thing, sir?
Milord, Kalyani Maternity Hospital Private Limited.
Kalyani Maternity Hospital Private Limited is subject matter of specially petition.
WPC number 6590 of 2012.
In the Supreme Court of India. The court considers it appropriate to await the decision of the Supreme Court in that sense. Mr. Acharya, we could do one thing. We could set down the two user charge matters on a particular day.
Yes.
For final hearing. And as far as the 9929 is concerned, we'll await the judgment of the Supreme Court.
As you Lordship pleases, I don't have any objection.
All right. List. In that view of the matter, writ petition civil 9929 of 2020 is adjourned. Sine die, awaiting the decision of the Supreme Court in the aforementioned matter.
In the interim order, they may continue.
Yeah. Liberty is granted to the parties to mention for listing after the decision of the Supreme Court. Interim orders to continue in the meanwhile. In these two matters, 11885 and 7090, list for final hearing on 8th December 2022.
There is the interim order. We are in fact not able to collect the revenue.
Interim order to continue. Interim order
to submit of earlier date, sometime end of October.
October is full of vacations, sir. That's the only problem.
For the last 5 years, but the 5 years, the corporation is facing difficulty in revenue collection. Although the hospitals and all that. That's the reason. The predicament in the corporation is deprived of collection revenue for last 5-6 years.
Right. All right.
So can it be in October or November?
No, sir, let it be this. All right.
Supplementary list item number 75.
It's item 75 on behalf of Mr. Dalai. I pray for a Passover.
All right.
Supplementary list item number 76.
May I please your lordship, item 76, I am appearing on behalf of Mr. B.K. Naik. My lord, this is a PIL filed challenging the order dated 14/10/2019 passed by the collector and district magistrate Jharsuguda regarding the construction of the road by Vedanta Limited besides the UGME High School.
Yes.
Well, as per the instruction, the road is still is being used and it is being dangerous to the children.
There's a counter affidavit filed by Vedanta.
My lord.
You don't wish to file a rejoinder, you do that.
Well, sir, need some time to file the rejoinder.
All right. Rejoinder to the counter affidavit filed by opposite parties 4 and 5 will be filed before the next date. What about the state's counter?
I think
in the meanwhile,
I think I have not filed the counter.
Will file its counter affidavit within 4 weeks and rejoinder that to also be filed before the same date. List on 20th December.
Well, 20th December. Always, ma'am.
Supplementary list item 77.
That's item 77 with regard to the removal of unauthorized.
Is that an affidavit?
Yes, Milords. Milords, the last affidavit has been filed on 17th of August, Milords. It would be on my lord's file. 17th of August 2022.
No, that after that 22nd August was listed. Oh, is that affidavit on record? 17th August. It's still not come on record, sir.
17th
August affidavit is still not on record.
It's
there.
Is there?
Milords has the 17th.
All right. The affidavit dated 17th August 2022 states that out of a total unauthorized construction of 18,621 by the 1st of August 2020, 1998 religious structures have been removed, 563 have been relocated, and 10,778 have been regularized. Full stop. It is stated that in the respect of balance 5282 religious structures, process is ongoing. Full stop. A further affidavit be filed before the next date. Based on 21st December.
Supplementary list item 78.
List before a bench of which Justice Chittaranjan Das is not a member. On October 10th.
Supplementary list item 79.
My lords, the date given.
Is it 10th October, my lord?
Yes.
Item 79.
Your Lordship, on behalf of Mr. Senior Counsel Pradipta Kumar Mahanti, Lordship, a counter is ready. It is yet to be filed today. It is to be filed today, Your Lordship.
All right. It is stated that the counter affidavit is going to be filed during the course of the day by state.
Your Lordship.
No, IDCO. That
IDCO
we have
opposite
filed the
number.
affidavit. That is sufficient for disposal of the case because IDCO is the lessee. We have granted lease to IDCO. I have annexed all the documents of which the lease was granted to IDCO. So I think IDCO is not a very.
All right. Yes.
My lord, in fact, your lordship wanted all to file the affidavit. If my learned senior says that it is sufficient, with your lordship's permission only, I am filing an affidavit which is in the nature of a submission. Because when I telephoned in the morning to my learned senior, Mr. Mahanti, to pray for an adjournment, he said he will oppose. So therefore, my lord, despite
because that is my instruction.
I am not taking offense to it. So therefore, I was constant to come despite not having a completely good health. Here, what has happened, this PL has been filed, your lordship, challenging the transfer of Gochara land in favor of the opposite party number 5 And in fact, the transfer was effected, first alienation was effected in favor of IDCO. So my learned senior saying that IDCO has no say is not correct, because in turn, IDCO has transferred it to opposite party number 9. Now, my lord, from the inception in the PIL, your lordship will see, though my lord, some of the annexes are in Oriya and English translation has not been given, for which I may be pardoned. My lord, the basic...
Let IDCO file its affidavit. Counsel for IDCO states that he'll file his affidavit.
Lordship may fix a short date because we have given list
my lord,
to DAB.
state has alienated, IDCO has given it to DAB. Why state is interested?
Yes, we are interested.
Because the DAB was to oppose.
The school is going to be established there. DAB public school. School is for the purpose of public, and naturally the government will be interested if a school is established there. No, Lordship, it will, some people, for obvious reasons, they are opposing all these things.
And also, our property of more than 2 crores have been transferred for 30 lakhs only.
So what is that to you? We are not going to use that for any bad purpose. It is for establishment of a school, DAV public school.
Your lordship may fix a short date, but I'll point out to your lordship all these things.
So your lordship may kindly have a glance. I have filed the documents.
My lord is observing that
just a minute. Allow me to speak. Your lordship can adjourn the case. I have nothing to say. This change of Kisam from Bagayat to, Gotar to that is already since last 40 years by the consultation authority. They have never objected it. They have never, because this change, it is all judicial proceedings before the consultation authority. They have never challenged it. And all on a sudden, after so many years of publication of Patta, they are saying that this is this recording of Kisam is bad because it is not in consonance with the old records. But in the meanwhile, there is consolidation operation, and your lordship knows there is full bench decision also. Once the consolidation authority decide the right title, interest, etc., that is final and binding. And it is this ROR status is since long, it is the same status is going on. And on the basis of that status, we have to IDCO, and IDCO in turn give it to DAB public school for establishment of the school. That how some of the villagers, how they are aggrieved and how they are prejudiced by that, I don't understand. Because there is, and the RI Ramin report is there, RI report, there is no only jhaun, your lordship knows from Puri Konark Road, some jhaun trees were there, not that there is any permanent forest growth. So it is a public interest litigation. Rather, you should support the cause of the.
All right, let it go. You say Counsel for IDCO states that the affidavit of IDCO will be counter affidavit of IDCO will be filed within.
By today, he is saying that today he is going
to be
file.
filed during the course of the day. All right. Rejoinder that if any be filed for the next date. The interim order as modified on 14, as clarified on 14 July 2022 will continue.
Your lordship was pleased to fix a date,
Yeah, I'll discuss.
May I, with your lordship's kind permission, file my affidavit. This is in the nature of a submission. One document I have annexed, my lord.
You will look at his and then file a fresh.
Much obliged, deeply obliged. And I'll also show to your lordship how your lordship's order has not been complied with, in fact.
All right. 16 November.
16 November?
Yeah.
My lord, it's too late, my lord. I pray that it may be in this month because...
But it's only limited stay we've granted.
No, that particular plot where we are going this, we have given it to DAV public school through IDCO. That over that land we have been asked not to...
All right, 21st September. All right, 21st September.
Obliged, man.
Supplementary list item number 8P.
Obliged.
May I please, my lord?
Yes, this is statute.
Yes, my lord. Kindly, your lordship's order not complied. They have not filed the additional affidavit within 3 days. They have also not deposited the 5,000 cost.
My lord, so far the filing of affidavit is concerned.
Noting in the cause list.
Filing of affidavit is concerned, Lord, that is also noting that that affidavit was filed. But the whole problem, the affidavit was filed on 26th itself, but in the evening hour, because therefore it was taken into record on date of 27th. But affidavit has been filed. But so far the cost is concerned that your lordship, and copy has been sought by my Lord friend, and he has endorsed it on 26th.
It is attested on 25th. So for the affidavit having been attested on 25th August 2022, the costs of rupees 5,000 is waived. What about, you have a copy of the affidavit?
Yes, yes, I have received, my lord. They have admitted that there is no such approval. Now it is here up to lordships.
Then
no approval.
Then remove the statutes.
That can be removed. The affidavit, your lordship can have a grants we have stated in the affidavit.
Yeah.
For the purpose of installation of statue, that is no such provision in the government guideline with regard to grant of permission. According to their Platinum Jubilee Committee, in which the petitioner was one of the member, and he has participated in that proceeding to have for installation of that statue. He was a party to that proceeding.
That is a proposal only, my lord. Unrecognized committee.
He first instance given his consent for installation of statue, and now he's coming forward for.
What is your stand? There's no need to approach the government for installation of statue.
No, there is no such provision for installation of statue.
They can install any statue, any school, any.
Because the for the purpose of development, the authority has been granted, power has been deliberated to the school management committee. They have to take a decision for the betterment of the school. I have enclosed that policy of the government.
Their consent is not also there. It is the Platinum Jubilee
Committee.
So far the government
neither they have sought for, and there is no such requirement in the for the purpose of.
No, if there's no requirement for a permission, then are you sure there's no requirement for a permission?
My lord, I may be permitted to address the lordship, my lord. My lord, I'm appealing on behalf of, I have instructions to appear on behalf of opposite party number 7, which is the Platinum Jubilee Committee, my lord. My lord, it is my instructions that there is no permission that is to be required under the regulations and committee that
No, instead of you saying it, we want the government to say it, whether permission is required or not.
My lord, the government counsel is also saying that no, there is no permission required.
No, let's see whether it actually says that.
Indeed, your lordship. My lord, clause 6 is what my learned friend for the petitioner is stating. Your lordship, may kindly have regulation 6. My lord has regulation 6, my lord. May I read?
See, their affidavit is not clear on whether such a permission is required or not.
Yes, my lord, it is clear, my lord. And page number 3, paragraph 5. That in view of the facts, and there is no specific provision guideline issued by the government with regard to grant of permission is as much as there was no such request was made by any authority. The permission for installation statute was not issued.
This is not clear on whether a permission is required or not required.
Yes, my lord. One and another thing, my lord.
That is no such provision is there with regard to that installation of statue or anything. That development committee, that they can take a decision.
I want to draw your lordship's attention, my lord. Their affidavit, page number 4. There are 2 committees. One is school management committee, another is school management and development committee. Who had installed the statute? A Platinum Jubilee Committee. Third one, they are not recognizing the same. An ex-MLA proposed, yes, my father's statue be installed. The present MLA said yes. And this is the result.
And the petitioner also one of the...
No, that is a proposal.
And he also consented for that. In that meeting, there was this decision. But statue is concerned, we have no problem. We can remove the statue.
No. We see, the point is, if you have nothing to do with the statue, how can you remove the statue then?
Because this is within the school premises of the government school. And if the it will,
so you have to take a stand. Only then you can remove it. And you are saying if anybody puts any statue, you have no problem.
No, that the school management committee has to take a decision.
No, let's say school management committee takes a decision tomorrow to install 20 more statues. Of each, the fathers or mothers of each of the committee members, they say my mother or my father, their statues must be there. All right. So 20 statues are tomorrow put in the school. Your government will say that we have nothing to do with it. If they want to have 20 statues, let them have.
Well, that is at least what the regulations say, Lordship. Well, the regulations have been prescribed that the community is given that power for decentralization of the education, my lord, and for other purposes in relation to the place where the community is there. So, my lord, if the school management committee deems it fit in the interest of their community, my lord, that is under their prerogative under the regulations to establish that. My lord,
And my lord, who is that gentleman? May I submit, my lord?
1 minute. Let him finish.
So, my lord, if the petitioner is aggrieved by any decision, my lord, of the school management committee or otherwise, my lord, there is a provision of appeal given under the same regulations that my learned friend is setting. My lord, may kindly see, my lord, what is his case? My lord, he states that under clause 6, there is a prior permission to be required. My lord, that is at least at page 10 of his writ petition, PIL. My lord, may kindly have page 10 of the writ petition, from where he states that there is a sanction that is to be required. On page 10, clause 6, that is the regulation that has been referred down. Every parents teachers association shall take decision with regard to raising of corpus funds, which in its opinion is required for the development of the school infrastructure with the prior approval of the concerned district officer. My lord, this is not in relation to the spending. This is in relation only to raising of the funds. My lord, whereas the development part, which my learned friend has not written down, that is there, my lord, it is under the signatures of the president and joint secretary. Your lordship would see that at regulation 15. My lord, may I just share the screen, my lord? So that regulation 15 is there for your lordship.
Where is it? Regulation 15?
Regulation 15, my lord, may kindly see school education fund, regulation, sub-regulation 2, my lord.
Where is it? Where are you reading?
My lord, it's the regulation, the community participation rules, which my learned friend has sought to invoke, my lord. Does your lordship have it, my lord? May I share the screen?
No. If it is there in the part of a paper book, tell us which page.
My lord, it's not there, my lord. I believe that it's the regulation that the petitioner has not annexed, my lord.
Or read it, tell us what it says.
Indeed, your lordship. My lord, school education fund, regulation 2. Funds can be utilized in such a manner as may be specified by the school committee in its meeting, and the fund shall be operated by the president and member secretary jointly. So, my lord, there is no permission that is required under the regulations for a prior approval to be taken from the district officer. My lord, under the regulations, this fund can be utilized after a joint parents-teacher meeting and the school committee's meeting have taken place, which in this case has happened. It has been approved. A subcommittee was created for the Golden Jubilee, for the 75th Jubilee celebrations. That subcommittee had given its proposal in which the petitioner was a party. That has been accepted by the school management committee, and they have utilized the funds to install the statue. Which, as per their own discretion, was somebody of standing, and as such, his proposal was accepted. So, my lord, now the petitioner at a later date comes up and says that for certain reasons, my lord, for certain obvious reasons, he is not happy with the installation of this person's statue. But whereas the committee in its wisdom has decided something. He is a member, he has a right to vote. If he is a member of the school committee, my lord, he has a right to vote, whereas it is one vote. If he is against it, my lord, there is a provision of appeal in regulation 14.
Where is the regulation 14? The appeal lies to whom?
My lord, the appeal, I'll just read it to lordship. In case of any dispute, problem in approval and functioning the school committee, the DI of schools in case of NFE centers and primary schools, center inspector of schools in case of upper primary schools, and joint director in case of high schools shall be the appellate authority whose decision shall be binding, shall be final and binding.
My learned friend had submitted there is a consent of school management committee. Where is that consent?
I'm sorry?
No. I think he's saying this is a platinum jubilee has approved it, not the school management committee.
My lord, this Platinum Jubilee committee was created under the school management committee for this Golden Jubilee, for this 75 Jubilee.
No, I know, but it's not the same as the school management committee.
My lord, he has not taken that. My lord, it is not his case. My lord, at least for the petition, it is not his case. My lord, now he's making a new stand. My lord, at least as per the petition, that is not his case, your lordship.
You've not taken this point in the petition.
My lord, this notification came into force on 28/9/2021, my lord. They have filed in counter.
That it was the Platinum Jubilee Committee.
There is no consent. Is this Golden Jubilee Committee, my lord?
No. Have you taken that point? Is the question.
No, that my lord, I have taken, my lord.
Where?
Who is this Golden Jubilee Committee?
No. Where is that? Where have you said that Platinum Jubilee Committee is not the authorized to take
Yes,
a
yes.
That's not here. Are the members of the Platinum Jubilee Committee different from the school management committee?
Yes, yes, my lord.
My lord,
Yes,
they are also
they
members.
have given it is counter, they have given the signatories, my lord. That is a proposal. They have translated the copy of the proposal, my lord. It is at running minutes of the meeting, annexure A/4 of the affidavit dated 8/4/2022. The members of this, they are the old students, my lord. Old student, ex-MLA, present MLA. The members are not, the members of the school management committee as well as the school management and development committee are not there.
I need to take it up in appeal then. Against
Indeed, your lordship. My lord, if it is agreed by any decision that has been taken, my lord, there is a provision of.
My lord, I will just check, my lord, whether this rule 2000, which I had relied upon, is still existing or not, my lord. Is in force or not. One time, one adjournment may be allowed. I will just check that.
It is only lying, my lord. This petition is only lying, my lord. There is any grievance from the petition. My lord, it's a PIL. My lord, the statute has already been established. It is not his case that the statute is no longer to be unrevealed. The statute has already been revealed. So, my lord, the pendency might, my lord, it does not help anybody's cause, my lord.
If repealed, where I will go?
So anyway, you can file an appeal to that.
My lord, I may be allowed to check it, my lord. Only one last chance, my lord.
Yeah.
I will check that. If it is repealed, then what I will do? I will be nowhere, my lord.
You say the affidavit dated 25th August 2022 of the district education officer clarifies that no permission was sought and therefore no permission was granted for installation of the statue. Mr. Mahapatra and counsel appearing for the DEO states that no such permission is required to be obtained from the department for installation of a statue. Paragraph. Counsel for the school, this college, is it or school?
Opposite party 7, the committee that was conducting this.
Very for opposite party number 7 points out that under the relevant regulations, there is a provision for an appeal, which should be availed of by the petitioner who participated in the decision of the committee of the Platinum Jubilee Committee to install the statue in question. Mr. Manthil and counsel to petitioner seeks time for instructions regarding this submission. Add his request list on next week. 14th September.
Obliged, madam.
Supplementary list item 81.
May I please, yours. My lord, this is a PIL matter, my lord. In this case, my lord, government filed counter, my lord. I have also filed the rejoinder. In this case, my lord, government of Orissa decided to construct a multi-storied ML colony, my lord. And by cutting 873 of trees, of my lord, old age trees, my lord. And that happened, the petitioner raised objection before the authority, and there are filed writ option before this honorable court. This honorable court directed the state government to file detailed affidavits, my lord. How much trees they have till yet, my lord? They are cut. They have not specifically mentioned in their counter affidavit, my lord. That happened, my lord. They have settled in their counter affidavit. They have to compensate, my lord, those trees they have already, my lord, cut, my lord. But in fact, my lord, I have filed a short rejoinder, my lord. In the rejoinder, my lord, I have already saw yesterday. There are two orders from Honorable Apex Court, my lord. First, in a special leave petition civil number 20547 of 28 page, starting from page 14, my lord. They are, my lord, in the lordship, my lord. In the first order, the Honorable Apex Court, the state of West Bengal, try to construct a road, my lord, by cutting the year-old trees, my lord. There, the Honorable Apex Court, my lord, interfered and constituted a expert committee, my lord. Thereafter, my lord, the Honorable Apex Court also, my lord, imposed certain guidelines, my lord. And enforcement that they constituted a committee in the order, my lord, at page 14, my lord. The subsequent order, my lord, order 25/3/2021, my lord. The Honorable Apex Court held it. There the issue, my lord, before the Apex Court, my lord, whether the Honorable Apex Court held, whether we should allow the government of West Bengal to fell the trees
in order to construct road over the bridge. Here, my lord, they wanted to construct the ML colony. We have no objection. I have no objection, my lord. They constructed the existing ML colony. There is existing ML colony there, my lord. 147 for 147 ML is, my lord. But they tried to cut all the trees, my lord. Year-old trees, my lord. 150 years old trees, my lord. But they are creating a environment problem last COVID during COVID time, my lord. Your lordship, there is shortage of oxygen throughout the country, my lord. And we have no objection at all, my lord, if they construct the ML colony over the, my lord, the existing, demolishing the existing ML colony, my lord. But in fact, they tried, though they have cut some of trees, my lord, they have not mentioned their counterproductivity. How they will compensate the same? The Honorable Appeals Court, my lord, in the Westmoreland case, my lord, specifically held the right of a clean and healthy environment has been recognized as the fundamental right under Article 21 of the Constitution of India. And also, Article 41A imposed duty upon the state to endeavor to protect and improve the environment and safeguard the forest and wildlife of the country. In that case, my lord, Honorable Appeals Court, my lord, one of the moot questions often involve whether there is need to fell the tree development project, how just fair compensation can be calculated from felling of trees by any authority, organizations which proposes such felling. We have no doubt that such compensation should be calculated and paid as per the project cost of the project, which necessitates the felling of trees, and such compensation must be utilized in the expert manner for create a better environment and most importantly increase afforestations. It is therefore imperative to make the realistic assessment of the economic value of tree which may be permitted to fell with reference to its value of environment and its longevity. With regards to the factors such as the production of oxygen, carbon, subsequentration, soil conservation, protection of flora, it is role in the habitat and eco-style, integrity, and any other ecological factors, my lord. Here, my lord, they have not filed any detailed affidavit with regards to protection of trees, my lord, and they simply stated that they can.
One minute. Just come to para 10 of the counter affidavit.
And 17 also.
But the joint, they have settled, my lord, but the committee, my lord, they're not the expert committee, my lord.
1 minute, please. Just read whatever. Let's read it and find out.
The joint tree enumeration was conducted by the official of a GA and a PG department, Tahsildar Bhubaneswar, OB and a CCL Limited, and a forest range officer. The enumeration list prepared by the joint enumeration team reveals that 870 numbers of trees, different species are coming under the project area. That the number of trees and different kind of species enumerated by the joint verification team indicated above below. My humble submission before
kindly read on.
My lord.
Para 11.
The mention the trees, my lord.
No.
Para
11.
That on receipt of the joint verification report, the Division of Forest, City Forest Divisional Forest Officer, City Forest Division has accorded permission by letter dated such and such, letter number such and such, lease dated 8/4/2021 for conservation and disposal of 870 trees for utilization of land for public work subject to condition that user agency shall plant 8,700 numbers of plant in the available place or the deposit of rupees 68,70,912 only as per the plantation cost norms 2021 for urban tree plantation for 3 years approved by Principal Chief Conservator of Forest and HOFF Odisha to take the plantation. The detailed breakup of the plantation cost charged by the DFO in indicated below. they have indicated the total cost, my lord, is 68,70,912, my lord.
So this cost has been deposited.
How they calculated, my lord? That they are not the experts, my lord. They can, for that reason, on the appeals court constituted a special committee, my lord.
No, are you questioning this?
My lord.
The calculation of 67 lakhs, 77,77,000. Only that you are questioning.
My lord, that is not there. The old entries, my lord, how they calculated, my lord. This they are not the
So you're questioning how they calculated the value of these trees.
My lord.
So do you have in mind any other expert committee?
My lord, if any expert committee, my lord.
No. Who's that expert committee according to you?
My lord, as per the Honorable Appeals Court, my lord, they have also constituted an expert committee, my lord. My lord, the Honorable Appeals Court, my lord, constituted Professor Nishikant Mukherjee, Director, Tiger Environment Center, number 21, Indra Sagar, apartment. But they are the experts, my lord. But here
they're experts, only experts all over the country, please. Do you have any particular expert in mind? You tell us. We'll ask them. No. If you have a particular expert in mind.
In the Orissa, there are experts are there, my lord.
Which are these experts, sir?
My lord, I'll provide their names, my lord. Can't take next week. I'll provide the names, my lord. That they may access, my lord. But it is the fact, my lord. It is not the fact, my lord. The entire, my lord, city of the Bhubaneswar, my lord, last during COVID period of shortage of oxygen, my lord. Due to that, my lord, cutting of trees, my lord.
Don't mix up two issues, sir. That shortage of oxygen during COVID has nothing to do with the...
My lord, I have two grounds, my lord. First ground, my lord, the avoiding the cutting of tree, can the government construct the ML colony or not? That is one question. Second question is, they have already got how they access the, my lord, the compensation, my lord. For that reason, my lord, pray, can I take on next week? I will, my lord, give the list of the
May I be permitted to submit one thing? I will just place two documents before your lordship. Your lordship will kindly have page 20 of my counter affidavit, annexure B/4.
Yes.
This is the permission granted by the
DFO.
Right. For filling up.
Correct.
And then your lordship may go to annexure C/4 at page 27.
Yes.
Already 68 lakhs and so has been deposited in favor of this department in lieu of cutting of 879.
So that he's questioning how this...
My lord, there is distinct between. This is for afforestation.
Yeah.
Because it's equal number of trees we will grow in a different area within the BMC area. And then your lordship, I will take your lordship to page 8 of my counter affidavit. I'm sorry, page 9.
No. Cost of raising...
3 places by utilizing that fund.
No, maybe. Should that fund be 67 lakhs or should be something more is what he's questioning. See, you've arrived at the cost of raising and maintenance of 870 trees by saying 870 into 10.
Yes, my lord.
8,700 plants at 767 per plant, including cost of gabion of rupees 285 each. So what you're doing is, you're only saying 10 times the number of trees that are cut, I will have plants. I will calculate the cost of the plants.
Yes.
You're not compensating for the loss of the trees.
No, at 3 places that is the afforestation.
This is the cost of afforestation.
Yes, my lord.
This is not the cost of the tree. See, when
because
you use vegetation...
land, the trees were managed.
No, those are very ancient trees. See, what happens to the Campa funds?
Your lordship may kindly see where is the location. Your lordship may kindly visualize. It is just adjacent to the secretariat.
No, maybe 870. No.
There are some
870 trees have been cut.
And nature of the trees may kindly be seen. All are not shallow or the valuable trees or...
We don't know. What he's saying, all he's saying is,
all
he's saying is what should be the value of these trees? We don't know. What you have done is, you've multiplied each tree into 10 more plants. So you've said 870 trees, we will plant 8,700 plants.
Yes, ma'am.
Then you've calculated what is the cost of each plant. Each plant's cost works out to 767.
Yes.
Then that gabion, that is where you will cover it with, that you have put a cost of 285.
Yes.
So accordingly, you've calculated the compensation. It is not, this is a cost for planting trees.
then I
It's
would
not the cost for
only-
the loss of trees.
Yes, ma'am. And then I would only pray to your lordship. Then this PIL should be confined to this only, that the cost determined by the district administration or the department with regard to afforestation, he is only disputing that cost, because we have already all the trees are removed, and now the construction work is already going on. So, and it is only we are doing by demolishing the old dilapidated MLA residence. We are only multi-storied building like in MP quarters in Delhi. We are doing that. So it is for the public purpose, and the existing houses are there, quarters were there. We are only doing it in a multi-storied building. So if this is the only allegation of the petitioner, then your lordship confine the PIL to that issue only. That whether the amount which was determined by the forest department or the opposite party number 1 is sufficient, adequate or not.
No. One is this permission letter which you read before. It simply says we are granting permission.
Yes, for 800. No, then we have calculated that calculation part is also there in the counter affidavit.
No. So it almost seems like if you ask the DFO for permission to cut a tree, he will anyway, as long as you say I will plant 10 more trees, I'll pay for the planting of 10 more trees, the DFO will just grant permission. Or will he apply his mind? See, the question is, tomorrow a private citizen goes to the DFO. He says, I am demolishing my house and reconstructing my house. There are some 10 trees inside the plot. I have to demolish, because of the sanction plan, I have to demolish all the 10 trees. Will the DFO simply calculate 10 trees are going to be cut? So let us have 10 into 10 more, which is 100 plants. He will say, you deposit the cost of these 100 plants plus gabions, and I'm granting you permission. Is that how it is normally granted, permission? That is something that you have to explain.
No, what my learned friend is raising the objection that this amount is not adequate.
Two things. He's raising two things. One is he's talking about amount. How did you arrive at this amount? In fact, this amount arrival is quite easily explained from your affidavit. You have not calculated the cost of trees. You have calculated the cost of plants which will be planting in lieu of the trees.
Yes.
You have not assessed the value of the trees that have been lost. That you have not.
Yes.
So that is one point. Second is, he says, how did you grant us permission at all?
I think that is not challenged by the petitioner. That permission is not challenged, I think. Yes.
No, that permission you put on record only after the counter affidavit. So he may not have been aware. In fact, he had filed this at the stage in June 22 saying, stop him from cutting down trees.
When they have these details, so they also cut some trees, my lord. But now, my lord, my instruction, there are existing trees.
You need to examine the Supreme Court guidelines on, Mr. Manthi, you'll have to examine the Supreme Court guidelines on how to determine cost of trees that have been cut.
Yes, ma'am. That I will do.
And that whether the state government will.
No, if the cost of the trees are to be deposited, we'll certainly deposit it. Because so far as the amount is concerned, we have nothing to allege or challenge it.
But for the future, see, suppose anybody applies for permission like this.
But it is, may kindly see, it is for public purpose. It is for construction of.
No, any guidelines. It's only, we are only on that. We are not saying there will be an occasion where no tree can be cut at all. Whether valid considerations have been kept in mind. That's the only question.
Yes.
There'll have to be some guidelines for this. What kind of projects will you permit it? That kind of a thing.
Mild. Lordship, give me time 4 weeks.
You see the affidavit, counter affidavit of the opposite party state explains inter alia that on 8th April 2021, the Divisional Forest Officer, City Forest Division, Bhubaneswar, accorded permission for single quotes conversion and disposal of 817 numbers of different trees, bracket as per joint verification list enclosed, unquote, subject to the condition that the use agency will put 8,700 numbers of plants in the available place or deposit rupees 68,70912 as per the plantation cost norm 2021 as approved by the PCCF and HOFF Odisha. Paragraph. The above cost has been arrived at by calculating the cost per plant as rupees 767 and the cost of gabion, GABBION, of rupees 285 each, together with 10% escalation for maintenance. Full stop. In effect, therefore, the cost of the 870 trees that have been cut has not actually been calculated. Full stop. Paragraph. Mr. Ragada refers to the Supreme Court guidelines and states that they should be applied for determining the actual cost of the trees. Full stop. In any event, he submits that this has to be done only by an expert body. Mr. Mohanty states that the government will study the Supreme Court guidelines and consider referring the issue of calculating the cost of 870 trees to an expert body. Full stop. The said exercise be completed within a period of 4 weeks and a further supplementary affidavit be filed, indicating what the cost of 870 trees that have been cut works out to in terms of the expert body's assessment. Paragraph. Additionally, the court would like the government to explain if there is any set of guidelines followed by the DFO while granting permission for cutting of trees for projects. This will be placed on affidavit before the next date. List on 17 November.
May I pray your lordship to indicate that this amount has already been deposited by
Yeah. It is further stated that the said amount has already been deposited by the
agency.
My instruction that there are some existing trees are there, my lord.
That we will see. If
they are not cut all the trees, my lord, 807 trees, my lord. My lord, they further, my lord, they directed not to cut my lord, existing trees, my lord. That is the, my lord.
We have decided that within 6 meters from the boundary will not cut. So that must be some modification. I will come with a better affidavit.
All right.
Man, how many trees are existing, my lord? They will.
All right. After lunch.
Miller's paper books have been prepared and my bail application will be taken up only provided your lordship doesn't take up the matter for hearing today.
All right. We are ready, sir.
Yes, my lord.
You have your paper book?
Yes, my lord.
Pardon, my lord? You have the paper book?
Yes, I have. Please, my lords. The appellant has been convicted, my lords, under section 302 read with 34 of the IPC and sentenced to imprisonment for life and to pay a fine of rupees 5,000 in default to undergo further RI for 1 year.
All right.
The prosecution story, my lords, is that on 21/3/2011, my lords, the body of the deceased was found lying in the Hattisala Padia, my lords, of Jaipur town, my lords.
Yes.
And thereafter the FIR was lodged alleging that on the evening of 20th of March 2011, this appellant before your lordship, along with another accused, Sheikh Mehboob, who is still facing trial, they had come to the house of the deceased and he had accompanied them on their motorcycle. And thereafter he was not found until his body was found on the next day morning.
Right.
The Sessions Judge, my lords, has relied upon two circumstances, my lords.
Right.
First is this last scene theory as deposed to by PWs 1, 2, and 3.
Right.
And the second is that a sword MO1, which was found lying near the dead body, was stated in evidence in court by PW6, who have been seen by him on the day of Holi in the house of the appellant.
Right.
The third circumstance on which the trial court has relied upon is the fact that the death is homicidal.
Right.
It is there always, my lords, in every case. So that cannot be a circumstance against the appellant.
Right.
Now, if your lordship will look at the judgment, my lords may look at page 25 of the paper book, my lords.
Yes.
The opinion of the doctor has been elicited there. It is written at page 25, the trial court writes, PW6 has opined that the cause of death of the deceased was due to hemorrhagic shock and coma secondary to multiple injuries over the body. Time since death was about 14 to 20 hours from the time of postmortem examination. PW6 has further opined that all the injuries were antemortem in nature and the death of the deceased was homicidal and all injuries except injuries 6 and 7 were sufficient to cause death of the deceased in ordinary course of nature. PW6 has proved the postmortem examination report as Exhibit 4 and his signature thereon as Exhibit 4/1. Evidence of PW6 and 13 further revealed that on 6/9/2012, latter had made a query to the farmer along with a sword, and after examining the sword, PW6 had opined that the injuries found on the dead body of the deceased were possible by means of that sword. He has proved his opinion as Exhibit 5 and his signature as 5/1. PW6 has also identified the sword being shown to him as the one which he had examined on police requisition. Nothing has been extracted by defense from PW6 with regard to his opinion relating to the nature of injuries, cause of death, and the weapon of offense in regard to the injuries. Of course, it is brought out by defense from PW6 that he has made corrections in the time since death of the deceased, but he has categorically denied suggestion put to him by defense that the correction was not made by him at the instance of police. Defense has not adduced any evidence to show that PW6 has made the correction to support the prosecution. This I don't understand. How could I establish this through what evidence? Now your lordship may look at the evidence of PW6, that page 87. Your lordship may look at page 89 of the paper book, where those paragraph 8 of his cross-examination.
Yes.
I have made corrections in my postmortem examination report about the time since death of the deceased. It is not a fact that at the instance of the police, I changed my opinion on the time since death from 24 hours to 30 hours to 14 to 20 hours in the postmortem report. I submitted the postmortem report in my office on 21/3/2011. It's not a fact that my opinion regarding time since death of the deceased is not correct and based on surmises. Now, if your lordship will look at Exhibit 4, my lords, the Exhibit 4 itself shows, my lords, about the corrections, my lords, that he has changed the time since death from 24 hours to 30 hours to 14 to 20 hours, so that it will sync with the finding of the dead body and the prosecution story that the deceased died at the time when the prosecution surmises that he was murdered, my lords.
Yes.
But the learned Sessions Judge, my lords, he says that I should have adduced evidence to show that I had made the correction to, that he had made the correction to support the prosecution. I don't know on what basis he makes this observation, because what evidence can I lead to that? So this is the homicidal aspect, my lords, on which the Sessions Court has relied as a circumstance. Then as regards the last scene theory, your lordship may look to the judgment at page 26, paragraph 7.
Yes.
Admittedly, there is no eyewitness to the alleged murder of Sheikh Ghulam Nabi. Prosecution case is based entirely on circumstantial evidence. Evidence relating to seizure of the incriminating articles, the medical evidence of the doctor, and the chemical examination report relating to the seized incriminating materials. The first circumstance which the prosecution has tried to establish, that the deceased Sheikh Ghulam Nabi before his death was last seen together with the accused Sheikh Javed and co-accused Sheikh Mahbub alias Raja, who is not facing trial in the present case. In this regard, it is found that 3 prosecution witnesses have stated to have seen the aforesaid 2 accused taking deceased Sheikh Ghulam Nabi with them on a motorcycle on the night after which the deceased was not seen alive by anybody, and on the next morning was found lying dead at the spot of this case. These witnesses are PW1, 3 and 11. PW1, the informant nephew of the deceased, has stated that on 20 March 2011 at about 8 p.m., while he himself, his paternal uncle, the deceased, his cousin, brother, his grandmother and his paternal aunt, wife of the deceased, were standing in front of their house at Ganganagar, Pathan Sai. At that time, accused Sheikh Javed and co-accused Sheikh Mahbub alias Raja arrived there on a motorcycle, came near, whispered something in the ear of the deceased, took him. At about 10:30 p.m., when his deceased uncle did not return, they went to the house of the deceased and searched for him, but they did not find the deceased. The evidence of PW1 further reveals they also went to the house of the accused Javed and co-accused Sheikh Mahbub alias Raja to inquire the whereabouts of his deceased uncle, but found their houses under fire. When they asked the neighbors of Javed, they disclosed that on that day at about 9:30 p.m., Javed and the family members of Mahbub had left their homes in a hurry. They searched for his deceased uncle for the entire night but could not find him. Evidence of PW1 further reveals that on the next day at about 8 a.m., while he was sleeping in his house, his brother-in-law Ilyas informed him over phone that his paternal uncle had been killed with both his hands cut and his body was lying at Sakitala. Now, as per this witness, the last scene is at 8 p.m. on 23/2011.
Right.
So far as PW3 is concerned, the mother of the deceased has stated that on the day of Holi at about 6 years back, at about 4 p.m., while her deceased son was present in his house, accused Javed and Raja came to their home, called her deceased son, and they all left their home on a motorcycle. So PW3 antedates the time plots to around 4 hours earlier. When her deceased son did not return home, at about 9:30 p.m., she herself and her family members went to the house of accused Sheikh Javed and Raja to know the whereabouts of her deceased son. And on reaching there, they found houses of Javed and Raja under lock. On being asked, neighbors of Javed disclosed that a short while ago, Javed had left home in a hurry. Evidence of PW3 further reveals that they searched their deceased son thoroughly, but could not trace him, and thereafter returned back home. Next day morning at about 8 a.m., Ilyas informed the informant over phone that somebody had killed her deceased son and thrown the body at Hattisad Padia, Jaipur. PW11, who has claimed the deceased to be his paternal uncle, has stated in his evidence that 7 years back, on the day of Holi at about 8 p.m., while he, the deceased wife, Sheikh Jahangir and mother of the deceased were present in front of their house. At that time, accused Raja along with Javed arrived there in a black color motorcycle, called the deceased to a side and talked something, and thereafter they took the deceased with them on their motorcycle. When deceased did not return home till 10 p.m., mother of the deceased informed the informant about the same. Thereafter, family members, including mother of the deceased, father of PW11, and informant, went to the house of Sheikh Javed to ask the whereabouts of the deceased, but reaching there found house of the accused Javed unlocked. Evidence of PW11 further reveals that on the next day morning at about 8 a.m., Ilyas informed the informant over phone that somebody had killed the deceased, and getting such information, they rushed to the spot at Hattisad, found the deceased lying dead, being inflicted with bleeding injuries on both hands and legs. Evidence further reveals that due to previous strained relationship between Javed and the deceased, he suspected that Javed and Raja might have killed the deceased. Defense has disputed the evidence of PWs 1 and 3 with regard to the fact of accused Javed and Sheikh Mahbub coming to the house of Ghulam Nabi and taking him on their motorcycle on the night of 20th of March 2011. It is categorically suggested by defense to PW1 in his cross-examination that Ghulam Nabi had taken dinner in a hotel on the relevant night, thereafter proceeded towards Hattisad with an unknown South Indian in an auto rickshaw. However, PW3 has not been challenged on this point, and she has only been suggested in her cross-examination that her son, Sheikh Ghulam Nabi, was not present in his home on the date of occurrence. PW11 has not at all been challenged on the point that Ghulam Nabi had not gone with accused Sheikh Javed and Sheikh Mahbub on the night of 20th of March 2011, as he was in the company of some other person. Now, my lords, this reasoning of the Sessions Judge, my lords, my submission is that that cannot be, because PW1 was the person who had gone to the house of this appellant and others in the night and had inquired about it. Neither PW3 has gone, nor, my lords, PW11 has gone there. So why should they be put in cross-examination about the fact that Ghulam Nabi had taken dinner in a hotel and proceeded towards Hattisad? Then the court writes like this: nothing has been extracted in the cross-examination of PWs 1, 3 and 11 to show any doubtful feature about the fact of accused Javed and Mahbub taking Ghulam Nabi with them on their motorcycle on the relevant night. So the plea of defense during the prosecution evidence about the absence of Sheikh Ghulam Nabi at his house on the relevant night is inconsistent. Coming to its own evidence in this regard, defense has examined DW2 Yunus Bag, an auto rickshaw driver, to show that deceased Ghulam Nabi was somewhere else on the relevant night. This witness in his evidence has stated that he knows accused Javed and deceased Ghulam Nabi. He has further stated to have seen the deceased lying dead at Hattisad Padia on 21/3/2011 at 11 a.m. when police was present there. Testimony of DW2 reveals that he had seen Ghulam Nabi on the night of 20th of March 2011 at about 7:45 or 8 p.m. at Jaipur bus stand. He has further stated that deceased had requested him to drop him at Bypass Road near Gandhi Chowk, and at that time 2 others were there with him at the bus stand. DW2 has stated to have dropped all the three in his auto rickshaw near Hathisal ground bypass road. He has pleaded ignorance about identity of the other two persons who were with Ghulam Nabi, but has stated that all the three persons were talking with each other in Telugu and Hindi. It is further stated by DW2 that on their way to Hathisal ground, the three had requested him to halt for a while near Krishna Talkies, Jaipur, and when he stopped there, one of them went to a liquor shop and bought something. It is further stated by DW2 that the three were talking in a high-pitched tone in his auto rickshaw, and on his query, they avoided saying they were talking about some personal matter amongst themselves. It is further stated by DW2 that it took him 15 minutes time to drop the three near Hathisal ground, and after alighting from his rickshaw, Nobby gave him rupees 100 towards higher charges. It is categorically stated by DW2 that the place where he found Nobby lying dead on the next day was near the place where he had dropped him and his two companions on the previous night, and the said place was an isolated one. Learned Defense Counsel during argument has contended that in the matter of appreciation of evidence in a criminal case, both witnesses for prosecution and defense are to be treated as part, and only because defense has examined its witnesses at its own instance, evidence of defense witness is not to be viewed with suspicion. I agree with this contention of the Learned Defense Counsel. However, as mentioned earlier, defense has challenged the fact of deceased going with accused Sheikh Zaved and Mehboob on a motorcycle from his house on the relevant night, only to PW1 by taking the plea in his cross-examination that Ghulam Nabi was actually at a different place and was found in the company of an unknown South Indian person in an auto rickshaw proceeding with him towards Hathisal. Number of unknown persons who were with Ghulam therefore differs in the suggestion of defense to PW1 and evidence of DW2. Accused has not stated about this fact during his examination under 313 CRPC. Defense has also not explained how DW2 is known to accused Zaved, and when accused came to know from him about the fact of deceased Ghulam Nabi being in the company of two others in his auto rickshaw on the night of 20th March 2011 from bus stand Jaipur to Hathisal ground. There is also no corroboration to the evidence of DW2 from any other source. Defense plea that Ghulam Nabi was with two unknown persons from 7:45 or 8 p.m. onwards on 20th of March 2011 does not inspire confidence due to the aforesaid infirmities and also in view of the reliable eyewitness account of PWs 1, 3 and 11, who all have categorically stated that they have seen Javed and Mehboob taking Ghulam Nabi on their motorcycle in their presence on the night of 20th March 2011 at about 8 p.m. No animosity of these witnesses with accused Javed has been shown, nor anything doubtful has been extracted from them by defense to show that they have deposed falsehood. As regards its plea of alibi, the defense has tried to show that Javed had not gone to the house of Ghulam Nabi on the night of 20th of March 2011 at about 8 p.m. and was actually in the house of his cousin Yusuf Ali. This cousin of accused Sheikh Zaved, who has been examined as DW3, has stated that on the night of 20th March 2011, there was a family function in his house and he had invited some guests. Accused Zaved had also come to their house on that night at about 7:30 p.m. to attend the said function. And after taking dinner there, while other relatives and guests departed for their respective houses, Zaved stayed back in his house that night. It is categorically stated by DW3 that he and Zaved shared the bed and accused Zaved was in his house throughout the night. DW3 is further categorical in his testimony that he had locked the gate of his house from inside, so no one could have gone outside unless the lock was opened. His testimony further reveals that he opened the gate only on the next morning and proceeded to Bodiguma Hat, and Javed departed from his house at 8 a.m. He has further stated that he returned back to his house at about 8 or 9 p.m. in the night, and on the next day he came to know about the death of Nabi. However, the plea of the defense, through the evidence of DW3 that Javed was in the house of DW3 during the entire night of 20th of March 2011, from 7:30 p.m. till 8 a.m. on the next day, is contrary to its earlier plea during prosecution evidence.
Panda, what is your argument?
My argument, my lords, is that the trial judge has gone on a roving inquiry to find me guilty when the PWs 1, 2, and 3 don't corroborate each other with regard to this last sin theory. And that is the only theory on the basis of which I have been convicted.
Right.
And defense evidence, my lords, I have led defense evidence to take a plea of alibi, my lords. Can that be gone into in this detail, my lords? Now, further what he writes, your lords, you may see. Defense plea through the suggestion put to PW1, the informant nephew of the deceased, PW2, the brother of the deceased, and PW3, the mother of the deceased, in cross-examination, is that on the relevant night, accused Javed with his family had been to attend a feast in the house of one Anwar, observing the third day of the obsequies of his mother, and had returned back to his home at 11:30 p.m. with his family members, and all were present in their house till the morning. In this context, the very plea of alibi taken by defense is proved to be false. As already mentioned earlier, PW11 has not at all been challenged in his cross-examination about the fact of accused Javed and co-accused Mahbub and Raja taking Ghulam Nabi with them on their motorcycle on the relevant night. From the above discussions, it is therefore clear that accused Javed and Mahbub had taken Ghulam Nabi with them on a motorcycle on the night of 20th of March 2011 at about 8 p.m. and he was last seen together with them. Now I will invite your lordship to look at the evidence of these witnesses in order to see whether the assessment of the evidence by the trial court was correct. Your lordship may see the evidence of PW11 first, page 97 of the book.
Yes, sir.
My lords, page 97, he says at paragraph 2.
Yes.
About 7 years back, myself and the deceased had gone to the house of Javed on the day of Holi at about 10:30 a.m. On that day, while we were present with Javed in his house, at that time deceased smeared color to the sister of Javed, which resulted in some verbal altercation in between the deceased and Javed. Thereafter, we left the house of Javed, and after reaching the house of the deceased, matter was discussed by us before the mother of the deceased. Now, one thing your lordship will appreciate, all these witnesses as well as the appellant millards, they are Muslims millards. So just because it was holy millards, smearing of color millards by the appellant by the deceased on the sister of the accused millards, which led to an altercation, is simply a story which has been cooked up in order to hide the previous enemy between the parties. Then he says, on the at about 8 p.m., while myself, the wife of the deceased Nabi, Sheikh Jahangir, and mother of the deceased were present in front of our house. At that time, accused Raja along with Javed arrived there in a black color motorcycle, called the deceased to a side, talked something, and thereafter they took deceased with them in their motorcycle. Since the deceased did not return home till 10 p.m., mother of the deceased informed the informant about the same. Thereafter, the family members, including the mother of the deceased, my father and the informant, went to the house of Sheikh Javed to ask the whereabouts of the deceased, but reaching there, found the house of the accused Javed under lock. Now, this witness has never gone in the night to the house of the accused. So the question of my cross-examining him with regard to this, that the deceased was seen in an auto rickshaw or was found moving here and there, that doesn't arise. That's what I want to submit.
Mr. Panda, do you want to continue on another day because it won't get over today?
But actually tomorrow I'll be out on sessions. Next week also I am packed, Miller.
You give us a date.
Your Lordship may take it up on the 28th of September.
All right, 28th. You see, Mr. Panda has been heard in part for the remaining arguments, 28th. All right.
Lords, can I make a small prayer?
Yes, please.
Other matters in the list where I am appearing, I may be accommodated tomorrow.
All right.
May I please, my lords?
Yes.
My lords, I pray, my lord, this matter will be taken up next week, my lord.
You're not ready.
But day first, I received the paperwork, my lord.
All right. Counsel to the
2019 appeal, my lord.
All right. To the counsel, the appellant stated to be in some difficulty. We'll have it after the vacation, then, 18th October.
18th October.
All right.
18th October, my lord.
Over, then we'll.